Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. We're going to start with committee member introductions, and then we're going to take up LD 2107 first and LD 127 second. And so Representative Caruso, would you like to begin introductions?
Love to. Good morning, everyone, and welcome. I'm Elizabeth Caruso. I represent House District 72, which is much of northern Somerset County.
Good morning. I am Mark Badman. I represent House District 3, Northeast Aroostook County.
Good morning, everyone. My name is Ellie Sato. I represent House District 109 in the beautiful town of Gorham.
Hi, it's nice to see a different crew in here than usual. I'm Adam Lee. I represent House District 89, which is downtown in New Auburn.
Hello and happy Friday. I'm David Sinclair, here for the people of House District 50, the city of Bath.
Good morning, everyone. I'm Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Milton, Hanover, Roxbury, Rumford, and I would love for Representative Lee to define the word different for us.
I decline.
Good morning. My name is Danny O'Halloran, and I proudly represent District 20, which is the majority of the industrial city of Brewer.
Good morning. I'm Amy Kuhn. I represent House District 111 in the town of Falmouth, and I serve as the House Chair of the committee.
My name's Ann Carney. It's nice to see everyone this morning. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and some of Scarborough, and I serve as the Senate Chair. We have two work sessions today, and I had announced a little bit earlier the order. I also want to let people know that the work session on LD 127 is going to be more of an information session. Our analyst Eli Murphy has worked really hard to gather materials for us to help us understand the legal landscape for that legislation. And so with that, we're going to open up the work session on LD 2107. This is an act to establish the Maine Nonprofit Security Grant Program. Thank you, Eli.
Good morning, Eli Murphy, Office of Policy and Legal Analysis. This is LD 2107 Act to establish the Maine Nonprofit Security Grant Program. This bill would establish the Maine Nonprofit Security Grant Program in the Office of the Attorney General to provide grants to assist nonprofit organizations to improve security at property owned or occupied by those nonprofit organizations to protect against hate crimes and terror attacks. The office administers the program and must develop guidelines and criteria to award grants to nonprofit organizations using a request for proposals process. Currently, FEMA provides states with grant money to address the purposes sought under this bill. Attached is a portion of the 2025 FEMA report indicating the background and purpose of the federal nonprofit security grant program. That would be a kind of federal ancillary to what is proposed by this bill. At the public hearing, we did hear from the sponsor, Representative Brennan, indicating a couple of amendments that he would request, one of which would be reducing the amount appropriated in the fund from $2 million to $1.5 million. And the second would be housing the grant program within the Maine Emergency Management Association, or agency rather, instead of the Office of the Attorney General. And so if you look at, I didn't draft out any changes, but if you look at your bill, the printed bill that you have in your files, a couple of changes. The way that would look really is if you go to section 2 where it says Attorney General, Department of the, and then it has the appropriation section, that would switch to it would be housed under MEMA. And then, of course, the amendment with the funding that would change in fiscal year 26-27 from 2 million to 1.5 million. The purposes would be the same. It would essentially be to supplement the work that they already do in appropriating these or awarding these grants that are funded by the federal government. I am not sure. I would need to go back and look, and I apologize that I don't have this right for you today. But it's not necessarily of substance. The section 1 of the bill, which lays out what the grant program is, it may be that language stays exactly the same and it's fine regardless of whether the grant is managed by the Attorney General or by MEMA. It may be that the grant it needs to be, you know, 5 MRSA 200W. It might just need to be in a different section of law. I did not go back and look to see whether this is housed under a list of grants that are controlled by the AG's office, and instead it needs to be somewhere else. That all being said, the substance of the language in section 1 would remain the same, regardless of whether it is MEMA or the Attorney General's office that is housing this grant program. Turning back to your bill analysis, there was a request of a bunch of information from MEMA. A lot of that I did send to you via email. One or a couple of pieces, especially the pieces that were really asked for. If you look to the back of your packet, it begins on my numbered page 11. There is data relating to the number of grants awarded by FEMA, who those grants went to, and the amount of money that each of those institutions received based on this federal nonprofit security grant program. We also have a member, the deputy director of MEMA here, who can answer probably a litany of questions in a much more concise and better way than I can. Finally, a preliminary fiscal impact statement from OFPR should be in your folder. That was based on the 2 million number that was in the original printed bill. My overwhelming assumption is if the committee amended this to be 1.5 million, the fiscal note would also change to 1.5 million.
Thank you very much, Eli. Committee members, are there any questions for Eli?
Oh. One more quick thing.
Yes.
Because I'm seeing, when I emailed you all that information, I did indicate, hey, something is wrong with one of the PDFs. I've since learned that was on my end. I believe that you all should have been able to access it, even though I could not. The second document that Supi should have passed out, that is that document that I couldn't access, but you should have it digitally and now in print as well. That is the security grant program application under FEMA.
Yes, Representative Crusoe?
Thank you. Thank you, Eli. So I'm just a kind of an obvious question is if all of these organizations, these nonprofits are already receiving grants when they apply for them, why can't they continue to do that and go skip through the state government and go right directly to FEMA?
That might be a better question for the sponsor, but if I recall from the public hearing, I think some of the concern is that these federal funds either are drying up or they're not available in a way that they once were. And so there's some concern that going forward, there might not be the same level of access to them as there would have, or as there has been in the past few years. And certainly, I know the sponsors in the room and could kind of expand upon that.
And I have another question.
Would you like to pose that initial question to the sponsor? And is your second question also for the sponsor, or would it be for Eli?
It would be for Eli.
Okay, why don't you go with your second question then?
So, how is it that the state can grant funds to nonprofits in like religious nonprofits?
The state has the ability to grant funding to really anyone with kind of a heavy asterisk. The asterisk is it can't say this money is specifically for religious nonprofits. It can say this money is for any organization that qualifies under X, and religious nonprofits can be some of them. I think even this grant funding is not completely to, I did scan through. It's not just religious organizations, though the vast majority of them are. I did see in 2024, Bates College received some of this funding. Shepherd's Godparent Home, I'm not sure if that is a religious institution or it sounded to me like a, a retirement home type situation. Yeah, so I guess my point being is that I don't think that the funding and I don't think that the federal criteria or this state criteria would only limit this funding to religious organizations. I think that under the big umbrella of what the criteria are, religious organizations would qualify.
And the big umbrella of hate crime. Whatever that.
Under the bill as printed, the big umbrella would be eligibility, be a tax exempt organization under Title 26 USC, et cetera. So a tax exempt organization under federal law is kind of the first umbrella. And then the smaller one is demonstrate the organization or the organization's facilities are at risk of hate crime or terror attack. And those are defined, defined terms in the bill. And so that would be the criteria. If a religious organization could demonstrate both of those pieces, they would qualify. If an educational institution could demonstrate both of those pieces, they would qualify. If some other nonprofit organization, say a climate organization, could demonstrate it, they would qualify.
Got it. Thanks. I'm all set.
Okay, and you do or do not wish to ask the sponsor? Okay, thank you. Other questions, committee members for Eli? Not seeing any. Does any committee member have questions for the sponsor? If you do, please raise your hands. Yes. Representative Brandon, could you please join us at the horseshoe? Welcome.
Good morning. I'm Representative Michael Brennan. I represent District 115, which is part of Portland. And I'm more than happy to answer any questions. And I don't want to recreate the public hearing, but at the public hearing, there were a number of specific questions that committee members had. Eli and I have been able to provide information and work through those things. But I do want to point out that Joe Legee from FEMA is here, and that he wouldn't be in a better position to answer specific or substantive questions related to FEMA and how this would be complementary. But if there are other questions that you'd like to ask me at this point, I'd be more than happy to answer.
Thank you very much. Representative Henderson, go ahead with your question.
Thank you, Madam Chair, and good morning. My question is related more to the reason, is there a current loss of federal funding that these programs are experiencing? And I think that if that's the case, what is the nature of the loss of that funding? What is the justification from the federal government?
And again, I would ask the representative from FEMA who be in a position to provide the history of that a little bit more. And the history of the funding has gone up and down over years. And at this particular point, people feel that the federal funding is in jeopardy going into the future. But secondly, there are also proposals that have been submitted to the state for FEMA for federal money that have been rejected by FEMA, but they've been approved at the state level. So with state funding, we'd have the flexibility to fund those programs that the state has approved, but that were not necessarily approved at the federal level by FEMA. And I have one statistic that somebody else can speak to, but at one point, the acceptance rate by FEMA was less than 50%. So we did have proposals in the state of Maine that had been endorsed by the state Office of Emergency Management that, again, were not funded at the federal level. But again, I'd ask the people from FEMA would be a little bit better positioned to answer that. So what we look, Representative, look at the money and look at the proposal as complementary to what the state is providing now, what the federal government is providing now, and will allow us to be more expansive and responsive to programs within the state of Maine. And then obviously, if federal money is in jeopardy, it would allow us to make that transition with state money much more easily in the short run.
Are you comfortable with answering how something can be approved at a state level, but not denied at a federal level? Or should we defer like the deeper types of questions?
Absolutely. You should definitely ask them.
That's fair.
The different, because I would not be able to give you a substantive answer about that.
Other questions, committee members, for the sponsor? A quick question for you. I understood at the public hearing that the FEMA money is primarily directed at physical structures versus the money that would be available under this state program would also allow for retaining, for example, event security for a signature event that an organization was holding. Is that one of the major distinctions?
Well, again, I would, but my understanding is that there clearly has been a bias towards infrastructure type improvements as security measures, as opposed to being able to have personnel at special events. Mr. Legit and I had a discussion about this beforehand. There seems to be some point of discussion about whether or not federal money allows for the hiring of off-duty police personnel as opposed to full security. I have spoken with the Commissioner of Public Safety, Mike Suschuk, and he is very clear about the fact that hiring off-duty police personnel is a better approach and provides better security than hiring for-profit security personnel. But I would allow the people from FEMA to talk a little bit more about that distinction. But Representative Carney, similar to you, and it's probably because of something I said, I think that the bias of the federal money has been towards infrastructure as opposed to event security.
Okay, thank you. Committee members, would people like to hear from the representative from FEMA? Yes, okay, thank you. Thank you
Well,
for
thank
being
you.
with us this morning.
And I'll still continue to stay here.
Great. Would the representative from FEMA please join us at the horseshoe? And if you could begin by introducing yourself.
Good morning, everyone. My name is Joe Legee. I am the Deputy Director of the Maine Emergency Management Agency, so MEMA, not FEMA, the state complementary agency. Happy to be here this morning. Happy to answer any questions you have relative to the federal program for sure, which is a program that we've administered as the state administering agency for all FEMA grants, this being one of them since its inception in 2020.
Thank you. Representative Kuhn.
Thank you for being here with us. I wondered if you could just give us a little bit of an overview of your review process when you receive applications. And in particular, I'm curious about instances where the available resources are less than the number of applications you've received and how you differentiate between applications.
Yeah, for sure, I can do that. So I think Eli covered some of the documents that we provided. So I think you have a lot of these and I'll reference those. The process within a fiscal year starts with that investment justification document. So any interested applicants start by filling out that investment justification. That collects a bunch of different information about what project type they're interested in, whether it's infrastructure, security, or otherwise, what their risk is, if they've had threats, that kind of information, as well as other demographic information about the applicant for the program. We collect all of those investment justifications. We review each one and we fill out one of the documents that you guys received was called a scoring tool. That's filled out for each one of those investment justifications. You can see the point system on there. That's not something that we came up with at the state level. That's something that was provided by FEMA, developed by FEMA for us to use to rate these investment justifications. So we use that tool. We follow that point system. That's largely done by a panel formed of our staff, our subject matter experts. I have my grant program manager, Stephanie Buzzle, with me in the room here today. She administers this grant program as well as several other FEMA and Department of Homeland Security grant programs. And then we have other agency experts that look at those investment justifications and fill in that scoring tool. After the scoring tool is filled in, we then take that information and we transfer it to the prioritization tool. That's one of the other spreadsheets that you guys were provided, also developed by FEMA. And that largely gets ranked by what the score is on that investment justification. I'll say from a scoring perspective, if you look through the criteria on that spreadsheet, it's largely split into a couple different areas. It's split into how complete is the application? Did they provide all of the information that was required on the application? And then how good of a job did they do defining the risk to their institution? And how good of a job did they do defining how the project is going to meet that risk or meet that need? We fill out that prioritization matrix for every single one of the investment justifications, every single one of the applications received. We then send that prioritization matrix to FEMA along with all of the investment justifications. So they get every application that we get. And then FEMA makes determinations based on that information on which ones they're going to award. If you ask me, what is FEMA's process to do that? That's a little bit trickier because FEMA, that changes year to year, and that's not information necessarily that they provide to us. Some years it does loosely follow the kind of prioritization matrix that we provided. Some years they jump around a bit on that matrix. For example, there have been years where they have prioritized new applicants for the program and given them extra points on their own scoring. And then in other years, they've prioritized previous applicants and kind of capability building projects over multiple years. So that's not necessarily something that we're privy to at the time of kind of our application for the grant program. Usually we submit the prioritization matrix and then we see the outcome at the end.
Thank you. Did you have any follow-up, Representative?
Not at this time.
Okay. Are there additional questions, committee members? Representative Sinclair.
Thank you, Madam Chair. Good morning. And if this question is better addressed to your program administrator, totally get it. But I'm wondering if for a given project, particularly a given project that is high in prioritization, whether first focus would be put on trying to acquire federal funds before going through the screening process for the state funds that would be available if this bill were to pass, or is it anticipated that you would pursue both streams simultaneously or something totally different? I'm wondering in particular whether we exhaust the federal possibility before we start to look to local funds.
Yeah, that's an excellent question about how we would kind of, if this were to come to be, how would we then look to administer the program? I think there's flexibility there. So I think the intent of from the sponsor in the bill, from the committee is really important here to guide kind of how we would administer the program and if there's a preference there in how that administration looks. I mean, I could speculate, there's probably a bunch of different ways you could do it. And I could speculate, but I just wanted to make that note that a lot of it comes down to sponsor committee and ultimately what the language is in the bill that's passed, if passed. But what you kind of outlined is probably the most obvious one, which would be to, if there is a federal program, to exhaust that program first. And then for those applications that are ultimately not funded, but that are eligible for the federal program, to look to the state program to pick up the slack on those ones. I think one of the things you were provided was a spreadsheet that goes down by fiscal year, and it shows how many applications were received versus how many were awarded. There is a delta there kind of between those two numbers. So certainly, and that delta generally exceeds, $1 million, $1.5 million greater in some cases, depending on that particular fiscal year. So that would be the most obvious solution.
Thank you.
That spreadsheet's on page 11 of your packets.
Thank you. Eli?
One thing that I'll note based on what was just said in terms of the administration of this and whether it's federal money first, et cetera, the way that the bill currently is written and would be, of course, it would be amended to sub out MEMA versus the AG's office. It directs in this case, the AG's office to administer the program and develop guidelines and criteria. And so right now, as contemplated, it would direct the agency that's housing the grant program to determine whether or not and how they would interact with federal funding, whether it's exhaust all federal funding and then go to state. And so if you want, as a committee, if you're looking to move this forward, if you want to leave that determination to the organization, you can. If you want to add in language that specifically directs them beyond what their internal organization is in terms of how they direct those funds, you can do that as well. And so that would take a bit of language in probably in that subsection 3, or my apologies, subsection 5 administration area of the bill.
Thank you. Additional questions, committee members? Yes, Representative Henderson.
Thank you, Madam Chair, and thank you for being here this morning. I'm trying to kind of hone in on the reason for the loss of federal funding, so it seems as though it's fluctuated, right? So that there's been robust years and kind of slim years in both Biden administration and the Trump administration. But that there's speculation that there may be some future loss of funding. Is that sheer speculation? kind of based on some national funding cuts, or do you actually have internal memos that you know that you're going to be seeing some funding cuts?
Yeah, we don't have any specific indications that this particular grant program is going to be cut or is targeted for being cut. It's, I think, and I'm speculating here, speaks to more the uncertainty of all federal programs at this time, all of the grant programs we administer. But I wouldn't call this one out specifically as one that's been targeted for elimination as compared to others.
Okay,
Is that clear? Would not.
okay, thank you.
Any other questions? Yes, Representative Sato?
Thank you, Madam Chair. I'm going along that same line of questioning. I'm looking at the spreadsheet that goes over the fiscal years in the application process. I'm seeing that in fiscal year 25, that there were 0 applications awarded to Maine. And comparing that to the previous fiscal years, that seems like an outlier. Am I reading that right?
Yeah, a little bit of context to explain that and why that's an outlier. Those applications have been submitted to FEMA and FEMA has not selected which ones they're going to award yet. So a bit misleading in that one. So they could theoretically, I mean, they'll award some subset of those 17 we expect, and we just haven't heard back yet which ones. Yeah.
Any other questions, committee members? Representative Lee?
Just sort of following the last few fiscal years, it does appear that substantially fewer of the applications are being granted. And so I'm curious why this is one-time funding rather than sort of predicting the need for it over time.
If I can clarify, speaking to the one-time funding in the state proposed program, the sponsor would probably be better able to speak to that. I'm just speaking to kind of the federal program and, and how it would look to administer a state program as complementary.
Yes, Representative Kuhn?
Thank you. I'm looking at the definition section for hate crime and program and serious bodily injury, terror attack. And I'm wondering if you know if those definitions mirror what is in the federal law, in particular under hate crime. There's a list of characteristics that we're familiar with from the Maine Human Rights Act, but then there are additional ones like homelessness of the victim or of the owner or occupant of that property. And I'm wondering, is that something unique to this, or is that mirroring language that you already use and deal with?
I'm not sure exactly. I'll say that the federal program, I was just talking with as you guys were discussing with our grant manager, I don't see the word hate crime used in the federal program specifically. I see it's focused more on violent extremism and terrorism are the words specifically used in kind of the purpose of the federal nonprofit security grant program versus the word hate crime. But I would need to deep dive kind of in crosswalk as you saw from the attachments. That notice of funding opportunities like 100 pages. So we could look through that and look at like federal regulations and things like that to see some of the definitions. But off the top of my head, the words used generally for purpose on the federal program are domestic violent extremism and terrorism.
Representative Crusoe?
Thank you, Madam Chair. Thank you, sir, for being here. Your last comments kind of are hitting something that has been bothering me with this bill. I'm not comfortable with how broad this is, especially with in terms of hate crime and in terms of any nonprofit, any hate crime. And it makes sense what you just said, that it's more specific with the federal grant program. I would be interested in finding out what that is. And feel that when we're looking at this and we're trying to complement or work alongside the federal program, that's what this seems to be doing, that we should, in terms of consistency, find out what they're defining, if that's the intention of this legislation.
Are you able to answer that question?
Yeah, if I understand and I took that as more of a request to kind of do crosswalk those things. We can certainly provide our thoughts on what the federal definitions are and as they kind of compare and contrast with what's used in the bill. As for like the intent of ultimately the language that is picked for the bill, I would refer to the sponsor on kind of what the intent is and the committee on what the intent is there of that final product.
Is the federal language that you're discussing with Representative Caruso, is it the same language that's in Part 3 of the FEMA application, where it says Part 3 risk? And it says the three principal variables: threat, vulnerability, and consequence. And then there's some additional elaboration of those different categories. Is that the information that you're referring to?
Not specifically, I'm referring to kind of the definitions, like the guiding purpose of the grant program. And as that relates to kind of preventing terrorism, terror attacks, and kind of how that's outlined, which would likely be more in this notice of funding opportunity document. If you look at kind of the purpose statements in there, but could also be in some of the other FEMA doctrine that we follow. There are various grants manuals and things like that we follow in the administration as well.
Okay. And you're saying that that's information that you don't have accessible to you right now?
Correct.
Okay, thank you. Representative Sinclair?
Thank you. In your years of working with FEMA in administering the grant that currently exists, the federal grant that currently exists, have you seen any suggestion or any rule that indicates that if there is a companion state level program that uses a slightly different definition, that in any way the federal funds would be imperiled?
I have not.
Thank you.
Anything else, committee members? Representative Henderson?
Thank you, Madam Chair. So I'm looking down through, I'm assuming that the, again, I'm looking down through a spreadsheet here. I'm assuming that you provided for us.
Yes.
Of all the monies that were awarded through 2020. Few reflections is that from 2020 to now, it seems that the amount of people that were awarded has been significantly increased, but also I'm looking at some rather sizable awards. And as I'm grappling with this, I'm thinking, how can we narrowly tailor this, right? Like, how can we just kind of bring it down to the people that are in need the most? I'm looking at Jackson Laboratories being awarded $150,000, Bates College being awarded $200,000. Even the Roman Catholic Church being awarded $200,000. Is there currently any state funds at all that are funneled into this program, or is it solely and completely being drawn down federally?
Solely federal this time.
Okay.
And if I can add some context to the 150 and 200 numbers there's a cap in the federal program. It used to be $150,000 total on the award. And then it pivoted in one of those fiscal years to $200,000 as the cap there. So that's why you see it maxing out at those numbers there.
I have a suggestion, committee members. Oh, Eli, go ahead.
Go for it.
My suggestion would be we've received some good information. It sounds like there's a lot of interest in amending this to include MEMA as the administrating agency, and also to amend the language to more closely follow potentially what's available under federal law or not. And so what I would like to do is to suggest that we consider tabling this bill, give the sponsor an opportunity to bring us back an amendment next week that includes those changes, and then any tailoring that the sponsor wished to do to more definitely define the scope of the grants, whether that's matching FEMA or it's matching some other criteria. And then if there are committee members who wish to engage with the sponsor and find out what that's going to be, and if they want a different standard, to please work on that and have that ready for the work session as well. Because it sounded like some committee members might wish for a narrower program than the sponsor. And so I guess my question to the sponsor is that an acceptable path forward for you?
Madam Chair, whatever is suggested by the chair is amenable to the sponsor.
Thank you.
I would like to point out just very, very quickly, and I have this here, there are 18 other states that have programs that utilize state funding as well as matching with federal money. So we're not breaking new ground, and we're not taking an approach that is different than a number of other states across the country. And maybe in the next week or so, while we talk about this amendment, we can look at what other states have done and how they've crafted a program to reflect both federal money and the state money.
Okay.
So thank you.
Yeah.
I'd be more than happy to work with Mr. Murphy and with representatives of FEMA to craft an amendment for the committee's consideration.
Thank you. Yes, and if we can, I'm envisioning, if you could please bring us a fully drafted amendment so that the committee understands exactly what's under consideration rather than having a really extensive third work session. Thank you. Second work session, excuse me. Thank you very much for being with us today. And so, Eli, what did you wish to say now that I've taken us to a different point?
The point that I was simply going to make, I know there's some conversation about limiting or wanting to limit who has access to these funds. I think that there are ways to do that. I think I would just provide a little bit of caution in terms of, you know, a situation where we want some nonprofits, but other nonprofits. I think in limiting who has access to funds within a certain category, that might be where you run into maybe some constitutional issues of equal protections and things like that, versus giving a blanket eligibility, and then, you know, you need to meet these criteria, if that makes sense. I don't know if I just walked that in a circle.
No, so for example, you couldn't forbid or prohibit any 501c3 that was affiliated with a religious entity from applying.
Right. Yes.
That has to be neutral with regard to religion.
Exactly.
Okay,
Yeah.
thank you. Any other questions, committee members, or anything? Representative Kuhn?
Thank you. Just an information request for Eli. If you're able to send us links to other state laws, that might be helpful to look at. I know I feel like this is an important policy and I want to support it. It will be helpful for me to know how it syncs with how other states have approached it.
Anything else, committee members? Does anybody wish to be? Oh, yes, Representative Crusoe.
Thank you. In addition, I'm interested in the verbiage, and I know you mentioned domestic, in terms of instead of hate crime, the federal grant discusses domestic terrorism and some other kind of terrorism.
There was, domestic violent extremism and terrorism were the two terms used federally.
Domestic, okay. I just wanted that clarification when, in terms of tailoring it.
Do you want the federal definitions that are associated with the federal program? Okay, great. Thank you. Anything else, committee members? Would somebody wish to make a tabling motion? Yes, Representative Babin?
For me. Thank you.
Sorry.
Thank you, Madam Chair. Just a request information. How are the funds monitored after somebody has received? If we could have a breakdown of that. Like who monitors the funds if a certain nonprofit receives $200,000? Do they have to report back as to how that's used? I guess that's.
Okay, so under the current federal
Yeah.
program. Okay,
Well,
great.
yeah, or both. Yeah. Can you answer that now? Sorry.
First, my grant manager, is that okay?
Yes,
Can. Sorry.
no, that's fine. It's good information to get. Welcome.
Thank you. Good morning. Once the award is
Can you
received.
please introduce
Oh,
yourself?
I'm so sorry. Stephanie Buzzle, the grant manager for this grant with MEMA.
Thank you.
Once the award is passed down from FEMA, then I meet with all of the organizations and we talk through all of the rules. Sometimes I'll have multiple one-on-ones with them for some technical assistance, but I do have multiple tracking systems and I'm take care of them as much as possible. And they reach out with questions. There are things that they are not used to doing because they don't do grants all the time. So I do have meetings with them to talk through that and make sure that they're following the rules, and specifically to the contracted security, that has been an issue. So I've talked through that with them and make sure that they're following the rules. They submit funds to us and we reimburse them. I'm not sure what else I can help with.
Thank you. That helps her.
Okay.
Representative Lee?
To the extent that the state sort of parameters would differ from the federal parameters, would that complicate your work substantially, or would it just be relatively simple to make sure that they're continuing to comply with rules?
If the state program mirrors the federal program, or somewhat mirrors it, it will be fine. We can work with them and it will be fine. As long as we have set guidelines before we start, everything will be fine.
Thank you. Anything else, committee members? Representative Henderson?
Thank you, Madam Chair, and good morning. The bill sponsor earlier indicated that there may be a scenario where a grant was approved of by the federal government, but not approved of through the state. Or vice versa, was approved of through the state, but not the federal government. How does that work if there isn't any current state framework on how the funds are administered?
You see if I understand that question. Once we send it to FEMA and then FEMA releases the award, they release us only the names of the applicants that they've awarded the funds to. And so I reach out to all of those organizations that did not receive the funding with a simple letter to let them know that they did not receive the funding. I'm so sorry. Do you mind repeating that question?
And so are you saying there's no administrative duties with regard to the applications that were rejected by FEMA because there is no money granted to those agencies because there's nothing available under state law?
So prior to 2024's grant, we would send out letters because that was an agency decision. And then after 2024 fiscal year's grant, FEMA requested that we do notify the applicants that were denied. So we do reach out to them. So once they're denied and that letter is sent, I don't have any other actions to take. Did I answer your question?
I don't think so, but I guess I don't know if it's perfectly necessary. I'm just somewhat inquisitive over the previous statement, but I don't mind connecting with you afterwards. I don't know if it's pertinent to the overall discussion we're having today.
Okay.
Thank you.
Anything else, committee members? Would anybody like to make a motion? Representative Kuhn?
Move to table.
Is there a second by Representative Sato? Let's try this with a show of hands. All those in favor, please raise your hands. And that is unanimous of those present. So with that, we'll end the work session on 2107. Thank you very much, Representative, and thank you. And thank you to the representatives from MEMA as well. Senator Hagan, would you like to introduce yourself?
Sure, thank you very much. I'm Dave Hagan, Senate District 10, several towns surrounding Bangor, not Bangor. Thank you.
Thank you very much. Committee members, we're going to get started on our next work session, and we'll take a break later. But yes, Senator Dusan? Yes, you may. And so we'll just, we are going to reach out to the sponsor of LD 127 and start with that as soon as he arrives. And here he is. Thank you for joining us, Senator Hickman. Oh. So we're opening a work session on LD 127. This is an act to strengthen legislative oversight of government agencies and programs by reaffirming the legislature's access to confidential records. It is sponsored by Senator Hickman. And as I mentioned at the start of our meeting this morning, this is going to be an information session presented primarily by our legislative analyst, Eli. And what he is going to do is to help us understand the legal background for this proposal. And with that, Eli, can I just turn it over to you?
Sure, thank you. So to frame the committee of materials that you have, Supi should be passing out a new blue memo from myself that looks very similar to the way our bill analyses look. We have had a few work sessions on this over the past couple sessions. And so as a reminder of the materials that you should have in your folders that may be of relevant use, you should have on Buff a packet of Chapter 37. That is the section of law that governs the legislative oversight of government agencies and programs, namely OPEGA and within OPEGA GOC, or I guess separate from OPEGA GOC, but containing our conversations. You should also have a bill analysis dated, yes, this is the first one, a bill analysis dated February 26th, 2025, and then a second one dated March 13th, 2025. All of that information I have not recreated that information. The information I'm giving you today is supplementary to that, but that might be of consideration for you as we're discussing this. Finally, as I mentioned, Supi is passing out the blue bill analysis. You are also getting in a separate copy a couple of materials that normally would be attached to that, but I will reference in that packet. So to begin preparing for this work session, I did consult with OPEGA and with the director of OPEGA to try and answer or provide answers to a number of questions regarding the statutory and historic background, both of OPEGA and GOC. I prepared answers to the following questions. The first of which is, what has been the historic guidance given to OPEGA and GOC with regards to confidentiality of and access to confidential records and information? Second, has GOC ever reviewed confidential information or records? Third, does limiting the scope of the current bill to working papers have a limiting effect on the information that GOC would have access to? Fourth, is timing a factor considered with GOC's interest in accessing confidential records and information? And finally, the fifth question is confidentiality, or is a confidentiality policy or non-disclosure agreement enforceable against a legislator? So turning back to that first question, the Office of Program Evaluation and Government Accountability, my apologies for that typo, was established in 2001 by Public Law 2001, Chapter 702. It came into its full function somewhere early 2005. And so many of the records that you see on, if you go to OPEGA's website, you see their meeting minutes for every meeting they've ever had. Those begin somewhere early 2005, those records of meeting minutes with the Government Oversight Committee. Since that time, the structure and function of the office has remained largely unchanged, both in practice and statutory authority. Since its inception, one of the understood duties of the office, and I will use, often I will use either office or GOC to mean office meaning OPEGA, GOC meaning the committee. So they're two separate entities, even though we look at them in a lot of functions together. And so one of the duties of the office was to inspect confidential information as it relates to a program evaluation being conducted by the office. And so if you look at Title III MRSA 997 subsection 4, again, that is in that buff packet that I mentioned, you should have information available to office. Upon request of the office and consistent with the conditions and procedures set forth in this section, state agencies or other entities subject to program evaluation must provide the office access to information that is privileged or confidential as defined by Title I, Chapter 13, which governs public records and proceedings. This committee is very familiar with Title I, Chapter 13, as we delve into FOA very frequently. The statutory language separates out the duties of GOC, which are established in section 994 and include evaluating the director of OPEGA, directing OPEGA to conduct program evaluations and other duties intended to facilitate those program evaluations conducted by OPEGA, such as issuing subpoenas, conducting hearings, and examining witnesses. The director of OPEGA and through the director, the staff of OPEGA have their own set of duties in statute and that are mainly in line with conducting and issuing program evaluation reports. The statute further creates separation from the duties of GOC and OPEGA in section 995 by stating that the director's duties must be performed independently and in nonpartisan manner, but under the general policy direction of the committee. The statute further goes on to say in section 996 that working papers in the possession of the director or an entity with which the director has contracted for the conduct of program evaluation pursuant to section 995 subsection 2 are confidential and exempt from disclosure pursuant to Title I, Chapter 13, including disclosure to the Legislative Council or an agent or representative of the Legislative Council. Government Oversight Committee, GOC, is established by joint rule of the legislature and is thus an agent of the Legislative Council. Turning to a couple of Attorney General opinions, in 2005, clarification was sought by the Attorney General as to advice on how the provisions governing access to confidential records in Section 997, titled Conduct and Issuance of Program Evaluation Reports, interface with confidentiality requirements applicable to state agencies under state and federal law. In a memo dated March 28, 2005, Linda Pissner, Chief Deputy Attorney General at the time, stated that, quote, the statute contemplates that access to confidential information will be afforded to OPEGA staff, but such information will not be incorporated in a report or shared with members of the committee, referring to GOC. Specifically contemplated in this memo was whether a legislative representative could be given access to confidential child protection records as required by federal law. The response from the oversight agency within federal DHHS was that legislative access, quote, was not consistent with the federal law requirements. However, the OPEGA statute is intended to give the staff access to, on an as-needed basis, to confidential agency records for the purpose of program evaluation. As a result, access to child protective records by the OPEGA staff when undertaking an evaluation pursuant to the OPEGA statute must be approved by the federal DHHS oversight agency. Coincidentally, at the time, it was the acronym was ACF. I didn't want to confuse that with our lovely ACF committee. On September 23 of 2005, the Attorney General published an official opinion, number 05-6, on, quote, whether or not OPEGA is authorized to access privileged and confidential files and records maintained by DHHS related to child protective services. In addition to referencing points made above, the AG opinion contemplates the implications of federal grant funding related to child protection programs based on the access of confidential records. The opinion states that Maine receives federal grant funding for a number of child welfare services, from foster care and adoption assistance to family preservation and support services. Under Title 42 USC, United States Code, sections 670, et cetera, or at sequence, but those sections, in order to receive this funding, the state must provide a plan which, quote, provides safeguards which restrict the use of or disclosure of information concerning individuals assisted under the state plan to purposes directly connected with, going on, any audit or similar activity conducted in connection with the administration or any such plan or program by any government agency which is authorized by law to conduct such audit or activity. And the safeguards so provided shall prohibit disclosure to any committee or legislative body other than the agency referred to in Clause D. The agency in Maine's case referred to in Clause D would be the Office of OPEGA specifically, with respect to any activity referred to in such clause, of any information which identifies by name or address any such applicant or recipient. Further on in time, GOC meeting minutes In a meeting minute summary of the Government Oversight Committee dated March 23, 2018. And again, as I mentioned, all of these meeting minutes since the inception of GOC are available on GOC's website in kind of a chronological order. During a discussion regarding the issuance of subpoenas to obtain records needed for review of the child protective system relevant to two named children, the director informed GOC that the procedure for records to come to OPEGA or to the Attorney General's office, or the procedure, the procedure is for the records to come to OPEGA or to the Attorney General's office, not for the records to come to GOC or in any public arena. It was explained that the involvement of the Attorney General's office in this instance was related to an ongoing criminal case involving the records, and the determination needed to be made whether any records should be withheld from OPEGA in light of that case. And I will say, see question 4 below, where I will return to ongoing criminal investigations in criminal cases. In May 24 of 2018, a meeting summary, it was again reiterated that under the law, access to confidential and identifying information related to child protective cases cannot be given to GOC, regardless of the public awareness of details obtained through media reporting. The director acknowledged that instances where OPEGA is reviewing specific cases versus a larger program review made it more challenging because the likelihood of individual identification would be much less. That meeting minutes contemplated a situation where, because both the media was reporting on these cases and using names and very identifying information, coupled with the fact that OPEGA was investigating a very specific instance versus a larger program review, the ability to discuss that information because it was so identifying made it difficult versus a larger, much more aggregate review of the program as a whole. Moving forward in time to the law court. In 2024, the Law Court Opinion Government Oversight Committee versus Department of Health and Human Services 2024 ME 81, the court determined that, quote, the committee's statutorily defined role is different from OPEGA's, and so is its specified access to information. Nothing in Section 994 authorizes the committee to conduct independent investigations, audits, or program evaluations directly. That is OPEGA's function. In its opinion, the court referred to the legislative testimony at the inception of OPEGA, referencing, quote, fears about the potential for partisan abuse, worries about unfettered access to privileged or confidential data, and a perception that the public may lack confidence in a process that could be viewed as overly political. One senator testified that we thought that in order for this office to function efficiently, it needs to be as far away from the perception of any kind of partisan politics to the public, and also those bureaus, programs, and entities that were being examined. Another senator said no committee person nor legislator would be involved based on this present legislation. They would never be involved in doing the research, further stating that no legislator has the ability to review the data that is being researched and influence the report prior to the report being given back to the committee. The committee then has the ability and the statutory authorization to accept the report, to deny the report, or to accept it in part. And so I want to pause there. I'm saying these statements that were made not for their validity, but just for in the inception of OPEGA, these were the things that were being contemplated as they determined what is going to be the function of OPEGA, what is going to be the function of GOC. Not that at any point those worries came to fruition, just that that was what was specifically contemplated at that time. And I'm going to pause and take a sip of coffee.
And while you're pausing, committee members, let's break this down into sections. Does anyone have questions for Eli about the information contained in response to question number 1? Yes, Representative O'Halloran.
Thank you. Currently on the releases that people sign, like the victims sign for consent, like when they're going to the doctors and social workers and stuff, that is for release to, you know, the doctors and all that, but it does not, but it's not giving permission to release their information to a political body, is it?
To my knowledge, that is correct. I have a copy for you of a release that is signed from the agency to the office of, to OPEGA. But that is a separate release, and that would not be a release that is signed by or reviewed by any individual whose records are being contemplated.
And just one thought,
Go ahead.
OPEGA is not considered to be a political body, right? They're strictly.
That is correct.
nonpartisan,
Yes,
so-
they are one of the nonpartisan offices, just like my own office.
And may I just ask one more quick one?
Go ahead.
There are consequences for members of OPEGA if they violate these laws, right?
That is correct. The consequences generally follow whatever consequences would be applicable to the agency who houses the records. Some records have higher consequences. Some even come with criminal penalties. I know we've talked a lot about tax records. Certainly disclosure of those records would have some sort of criminal penalty. I can't speak for all of the penalties for all the various records, but I imagine there's some level of spectrum of this record has this sort of penalty versus this record has a higher penalty. But yes, there are, for whatever records that are accessed by OPEGA, OPEGA would be bound by whatever penalty for disclosure of those records that the record home agency is bound by.
Thank you. Can I ask one more quick, easy answer question?
I don't see any other hands up, so
Okay.
please go ahead.
There are no real consequences for elected officials that if they get this information and they leak it, correct?
I'm going to get to that in question number 5. There's a bit more complex answer to that. It's likely that there would not be certainly any criminal enforceability
Right.
to a sitting legislator.
Thank you.
Other questions, for Representative Lee?
Can you tell us a little bit about the concurring opinion in GOC versus DHHS?
Off the top of my head, what I can off the top of my head, the substance of that concurring opinion, is certainly I pulled it wrong, document is ultimately that the legislature has the ability to give that access. In statute, it is not given, but should the legislature so choose, they could give the ability for that access to GOC. I didn't specifically prepare that for today simply because I was directed to look at what the historic framework has been versus going forward. But I can look more into that specific concurring opinion.
I just read it a little differently. I read it to say that the current legislation would allow GOC to review documents that are in the possession of OPEGA after OPEGA has created a report. But then in footnote, I think Justice Lawrence said, the gulf between my concurrence and the majority opinion, it should invite the legislature to maybe look at this issue via legislation.
And I will review that concurring opinion as well.
Any other questions for Eli about section 1 of his memo? Yeah, I'm not seeing any. Thank you, Eli.
Okay. Turning to section 2, has the Government Oversight Committee ever reviewed confidential information or records? Attached to the memo, and this is in that separate white couple of pages you got, are a list of instances in which GOC has entered into executive session. Of the 7 instances since its inception, 3 were related to consultations with attorneys or in relation to, ongoing litigation. 2 were personnel issues. As stated, one of the duties of the Government Oversight Committee is to review and appoint their director. And so those instances were to discuss that. And then finally, the final two were for the purpose of reviewing a draft version of an OPEGA report, which is confidential by statute until published. The footnote on that sheet that you should have indicates that those last two, the reviewing of a draft report, is not the common practice, as reports have been presented to the public and to GOC simultaneously for at least 20 years. And so the general practice has been, to my understanding, not to present the draft opinion or draft report at an earlier date to GOC and then publish it to the wider public, but to do them at the same time. And so that executive session has not been used since looks like 2005 and 2006 for that purpose.
Thank you. Committee members, questions about the information related to item number 2? I have a question for you, Eli. In the footnote, the word simultaneously is in quotation marks. Is that actually that word used in the statute?
I don't believe that it's used in the statute. I'm not sure. I can look. The footnote is on that white sheet that lists the, yes. Submission of final report to the committee. On page 5 of that buff packet, this is in section 997, subsection 2. The director shall notify the committee when each final program evaluation report under this chapter is completed. The report must then be placed on agenda for a future committee meeting. At the meeting where a report appears on the agenda for the first time, the director will release the report to the committee and to the public simultaneously.
Thank you. Anything else on point 2, committee members? Seeing none. Thank you, Eli.
All right, question number 3. Does limiting the scope of the current bill to, quote, working papers have any limiting effect on the information that the Government Oversight Committee would have access to? Working paper is defined under Title III in that same buff packet, section 992, subsection 7 as follows. Working paper means all documentary and other information acquired, prepared, or maintained by the office during the conduct of a program evaluation, including all intra-agency and interagency communications relating to a program evaluation, and includes electronic messages and draft reports or any portion of a draft report. So it is my opinion, by reading of this definition, limiting the scope of LD 127 to only include or only provide GOC with access to OPEGA working papers would not provide a more limiting option, as opposed to using the language information and records as is contemplated in the drafted bill and the various amendments this committee has seen over its work on this bill. So I don't think that there would be any substantive difference changing that language.
Okay, thank you. Any questions about that, committee members? Representative O'Halloran?
Thank you. Would you agree that it's true that oversight evaluates systems, processes, and outcomes for compliance? That's their function, right?
Their specific function is, it's listed in the,
Just basically, that's their basic function. So
Well, hold on, Eli. I think Eli wants to answer your question.
in different language, yes. I
Okay.
mean, yes.
So what's withheld are personally identifying and deeply sensitive details, because would you say it's true because they do not improve policy analysis and they can increase harm and they create risk without benefit? And there's no criminal accountability for elected officials if information is leaked?
I can't speak to the policy behind either this this proposal or what would change in terms of if this was to come about. I think that OPEGA's function is to not act as a policy committee.
Right.
Or OPEGA's function as an office is not to act as a policy influencing
Right.
driver.
But I guess the heart of my question is, it was set up this way to begin with because taking in all this personal information does not improve policy analysis, correct?
I can't speak to whether taking it in would improve or not improve policy analysis.
Thank you.
Any other questions with regard to item 3, committee members? I know that you spoke with the director of OPEGA, Eli. Do you have a sense of, or could you give the committee a sense of whether within the scope of working papers, there are documents including like images of injured children and other things that would be, well, let me not characterize it, but images of injured and abused children. Would those images be part of working papers?
I guess the answer to the question, I don't know specifically what is contained, and certainly because I, in my position, don't have access or want access to those information. So I'm not sure what is contained in any individual working papers for any individual review or reports. Certainly they could be. And so if they are within the reports that have been worked on by OPEGA previously, there may be, I have no information to say one way or the other, given the kind of content of those reviews. I would assume that there probably is. But they certainly, if it was relevant to any program evaluation or review or any investigation they were conducting, they certainly would have access to that, yes.
Thank you. Any other questions, committee members? Yes, Representative O'Halloran.
Following on Senator Carney's question, like when I look at this, some of the examples that could be exposed would be medical diagnoses of mental illness, substance use, pregnancy status, autopsy findings with death details, therapy notes and clinical assessments, sexual abuse disclosures, domestic violence narratives, names and identifying details of children, family histories involving addiction or abuse, and statements given during moments of extreme trauma. And I guess I'm just really struggling to understand how this is needed to set policies and examples of that stuff. I mean, none of these,
So-
the agency's not, I mean, none of this comes to say whether or not the agency is acting appropriately under the law.
So Representative O'Halloran,
Is that
just to,
correct?
Eli can try to answer, but just as a reminder, we're really trying to understand the framework and not debate the
Right, that's-
policy
I'm
right
not
at this
trying
time.
to debate, but I'm just trying to say this type of information, because this is very sensitive information, so I'm trying to take this very seriously. So I'm just struggling to understand how this type of information is going to determine whether or not the agency is acting appropriately under the law, because that's such private information. Like I'm struggling to see how that
The
to do that.
why it is needed is not a question that I can answer. That may be a question for the bill sponsor or other policymakers in this room or in the legislature as a whole. With respect to the types of records, I can't speak for how OPEGA goes about their reviews, but in a situation where they are being tasked with reviewing whatever it is that GOC tasks them with reviewing, if the information that you were referencing is relevant to whatever it is that they're being tasked with reviewing, they would have access to it. Yes. OPEGA as the staff, OPEGA as the
Right,
office.
OPEGA does.
Yes.
I'm just talking about the legislators. I mean, I don't see how this is helping them. But
And that's not a question I can answer.
Yeah,
get
I think
that. I
that's a
get that.
policy
Yeah.
question. Anything else, committee members, on section 3? Okay, thank you, Eli.
Question number 4, is timing a factor considered when GOC's interest in accessing confidential records and information? While OPEGA has the ability to request records relating to program evaluation being conducted by the office, there are certain situations that may limit the timeliness of acquisition by OPEGA. In an instance of ongoing criminal investigations or active criminal charges, as I mentioned before, the Attorney General may restrict the records that OPEGA has access to while that criminal case is pending. However, once a criminal case is completed, information may be disclosed. And so within the scope of Child Protective Services information. And so a lot of this I've been kind of keeping in the scope of Child Protective because that has been kind of the catalyst for this conversation. I do want to pause and say all of this it's any type of records for any type of review that OPEGA is doing. So it isn't just Child Protective, it's any records for any situation. The examples I'm using are in this realm because that's what we've been talking about. So within the scope of Child Protective Services information, under Title 22, Section 4008, all department records that contain personally identifying information and are created or obtained in connection with the department's child protective activities and activities related to a child while in the care or custody of the department, and all information contained in those records are confidential. However, as these records relate to a criminal case under 4008-A, notwithstanding any other provision of law, the Commissioner, with the advice of the Attorney General, may disclose information as set forth in this section regarding the abuse or neglect of a child and the investigation of and any services related to the abuse and neglect if the Commissioner determines that such disclosure is not contrary to the best interests of the child's siblings or other children in the household, and any one of the following factors is present. Paragraph A, the alleged perpetrator of the abuse or neglect has been charged with committing a crime related to the allegation of abuse or neglect maintained by the department. In instances where a person has been charged with a crime that alleges abuse or neglect, the Commissioner, quote, and this is again part of the law, the Commissioner shall make public disclosure of findings or information pursuant to this section in situations where child abuse or neglect in a child fatality or near fatality, with the exception of circumstances as determined with the advice of the Attorney General or appropriate district attorney, in which disclosure of the child protective information would jeopardize a criminal investigation or proceeding. In practical terms, an OPEGA report relating to a child protective case that was conducted while criminal proceedings were ongoing, and there is a report dated May 2018, amounted to 7 pages. Whereas a report that was completed after the conclusion of a criminal case, allowing for the Attorney General to provide access to significantly more information to OPEGA, resulted in a report dated September of 2024 that was much more comprehensive at 63 pages. And so timeliness of these requests for information does come into play with the amount of access that OPEGA is given when it relates to ongoing criminal investigations. And I know that not all access to records may involve criminal investigations. I know that this committee did request OPEGA look into the potato seed program. I'm not sure that any criminal investigations will come about from that specific program, but it is analogous to other types of reviews that OPEGA does conduct.
So in other words, even OPEGA's access to records regarding an investigation it's currently involved in are limited under this statute that allows the Attorney General to withhold the information during the criminal investigation.
Correct. Yes.
Any other questions about section 5? Actually, I don't think we even finished section.
Nope, that was section 4.
Section 4, excuse me. Okay, thank you.
Okay. Finally, section 5 is a confidentiality policy or non-disclosure agreement enforceable against a legislator. When accessing confidential information, OPEGA staff, and I mentioned some of this earlier, OPEGA staff sign agreements with the agencies that are providing the confidential information, which include the same penalties for disclosure that the agency itself is bound by. In some instances, this includes criminal penalties for disclosure. I'm going to pause there. Attached in that white packet that you got, in addition to those list of GOC executive sessions, is a copy of the program evaluation agreement with the Department of Health and Human Services, Office of Child and Family Services. I will note, this is one of the agreements used for one of those recent evaluations and reports that has been published by OPEGA. Even though the information in those reports is public, even though all of the names related to this request it's very out there, after consulting with the Attorney General's office before providing me with a copy of this, the director of OPEGA was required to redact. You'll see in that first paragraph, OPEGA's work on the review of child protective systems relevant to the cases of, and then there's a blank. So even though the names of these cases are out there in part of OPEGA reviews, still redacting that identifiable information has been requested and continues on in any spaces that includes this legislative space, just as a point to make in the continuation of redacting that information. In the white soup you should have given you, it's the top one was list of GOC executive sessions. And then there's also the State of Maine Office of Program Evaluation and Government Accountability, agreement for access to confidential records, et cetera. I think it's the sheet you're right in front of you. It's not redacted in black, it's whited out, yes, yes. So by contrast to those penalties and requirements of OPEGA staff and the director, for a legislator, there's broad immunity when acting in the legislative capacity for things said and information shared, beginning with Maine's Constitution, Article 4, Part 3, Section 8, which states, this is known as the Speech and Debate Clause, members exempt from arrest, freedom of debate. Senators and representatives shall, in all cases except treason, felony, or breach of the peace, be privileged from arrest during their attendance at, going to, or return from each session of the legislature, and no member shall be liable to answer for anything spoken in debate, either in House, in any court, or any place otherwise or elsewhere. Further, under the Maine Tort Claims Act, an act that this committee is very familiar with, Title 14, under Section 8104B, states that notwithstanding 814A, a governmental entity is not liable for any claim which results from subsection 1, undertaking of legislative act. So undertaking or failing to undertake any legislative or quasi-legislative act, including but not limited to the adoption or failure to adopt any statute, charter, ordinance, order, rule, policy, or resolution or resolve. It is unclear whether a legislator who disclosed confidential information learned through a process contemplated by this bill could face any enforcement action pursuant to any agreement signed with a record-holding agency without violating these constitutional and statutory provisions. Constitution contemplates being charged criminally. The statute contemplates being subject to a civil suit. And so there's broad immunity, both criminally and civilly, for legislators acting in their legislative capacity, regardless of whether they are disclosing confidential information. There may be some space of enforceability, say an non-disclosure agreement says, oh, if you disclose this confidential information, we can strip you of committee, something that is within the legislative power, specifically within this legislative space. I think that enforcement ability does have a ceiling, and the ceiling is fairly low in that it is within this legislative space.
Thank you, Eli. Questions, committee members? Yes, Representative Lee?
Probably not a lot of case law on this, but as I read the speech and debate clause, it would be some level of immunity for things spoken within the House chamber, but say legislator gets confidential information and then shares that, say, with a news source or a third party entity. I don't see this providing them that immunity. Do you?
I think that at the last clause of that sentence, spoken in debate either in the House, in any court, or any place elsewhere. I think that place elsewhere might open up enough of, if I'm speaking as a legislator, even to the news, one could argue, and certainly, as you mentioned, there's not a whole lot of case law under this, but one could argue that that is covered in this immunity.
I see that in any court or place elsewhere as accountability. They can't be held for accountability in any court or place elsewhere. It's an ambiguous phrase, and I guess in the absence of case law, we don't know what the result would be.
Yes, Representative Sinclair.
I realize that this question and the accompanying answer are directed at potential enforcement against a legislator or lack of potential enforcement against legislative action. But in order to weigh the importance of a likely lack of enforcement against legislators, I'd like to know how effective the availability of both civil and criminal remedies in the OPEGA context have been. Do you know whether, since its inception, either OPEGA as an office or any agent of OPEGA has been held either criminally or civilly liable for a breach?
I do not definitively sitting here know that as 100% data. I think my understanding is that it is a no. There's never been an instance where that confidentiality has been breached. I do know, as with any access to these records, and sometimes painstakingly, each agency that they access records for, they are signing a new agreement with that specific agency.
Other questions, committee members? Eli, do you know if the agreements that OPEGA nonpartisan staff sign with each agency, do they allow anyone within OPEGA to look at records related to any investigation that is ongoing or has been conducted by OPEGA?
They do not. OPEGA is split up, and I don't have I'm not even sure that there is one kind of a map of where each of the individual analysts in their office, what their content areas are. But there are analysts that, say, deal with tax information, and then there are analysts that deal with, child protective or other things. The records that they see are completely separate, and only the individuals in the office that are dealing with that specific case and thereby sign on to that agreement with the agency would have access to the records. It would not extend to anyone else in the office other than those specific instances. And so if you look to that same agreement there, and you think of like with legislative confidentiality, there's a director of the office, and then under the director's umbrella, everyone else within that office is subject to that director's authority. This is different in that it is a confidentiality agreement with an agency. And so if you look at that application, you will see listed each individual member of that office and only those individual members of that office that would have access to those records, not every member of that office.
So for example, you might ask a question related to some amendment you're working on of a colleague within OPLA, but that procedure can't happen in OPEGA unless it's within the small group of people who are assigned to a particular investigation.
Correct. Yes.
Other questions for Eli, committee members?
And so I guess as a kind of broader scope of that, to put it in judish words, say you give me authority to go work on an amendment with, this morning we talked with Representative Brennan. I'm going to go work with him on an amendment for the nonprofit security grant program bill. I could say, hey, Janet, I have a question. Can you help me with that? And that's completely fine. In the instance of OPEGA, if there's an agreement with, putting me in that shoes, if I was to go and have access based on an agreement to those records, I couldn't then go and say, hey, Janet, I have a question about this. Can you help me with this? I could only discuss that information with those signed individuals on that agreement.
Thank you. Additional questions, committee members? Eli, thank you for gathering this information for us. And I did want to indicate to committee members that I also went and had a conversation with the OPEGA director, and the OPEGA director informed me that he's actually not permitted to come and speak to us and answer our questions. And that is why I asked Eli to meet with him and then prepare an analysis of the framework and give it to us so that we would have the information, even though the director is not able to provide testimony to us. And so I just want to open it up to general questions that committee members might have for Eli. Representative Henderson?
Thank you, Madam Chair. Just out of curiosity, I guess this is a question for you. Do you know what is prohibiting him from speaking to us, if it's internal policy or statutory restrictions?
Eli might be able to answer that question.
I don't know that there is it's not something specific to OPEGA. I don't know that if there's anything in the statute of the legislature itself. It's the general practice of the legislature, and it may be written into the rules somewhere. I don't know where exactly off the top of my head, but it's the general practice of the legislature not to have the directors of our nonpartisan offices coming to testify before committees on the legislature as a whole. It's, we are there's a separation between advocacy and fulfilling our roles as nonpartisan staff. And I think we get into kind of a gray area where it comes to things that deal with the legislature itself. And so obviously this legislation would affect greatly the director of OPEGA and OPEGA as an office. They cannot, because of our, nonpartisan and our positions as service members to the legislature, we are never going to be advocating one way or another for any piece of legislation. Coming before a committee has that kind of space of advocacy, regardless of whether you look at it. And so I think that there being that separation of, I'm the analyst to this committee to provide kind of information. He can provide me information just as a way of background, but he wouldn't get up here and say, oh, committee should do this, committee should do that, etc. And so I think that the practice is, it's mainly one of trying to keep our nonpartisan offices separate from that space of advocacy or policy decision-making.
That's helpful. Thank you.
Additional questions, committee members? Is this something that we need to let settle for a little bit and come back to this legislation? Representative Lee, I want to make sure everybody has an opportunity to ask questions. Go ahead.
I'd be interested to hear from the bill sponsor as to where we are on text right now. I'm just noting that the first work session we had on this was nearly a year ago.
Mm-hmm.
And I don't know what changes have occurred in terms of the legislation. And so I'd like to hear where we are on the legislation.
Okay. So I have been working with the bill sponsor on an amendment, and as has Eli, and we haven't distributed that in advance of this information session because I, as chair of this committee, wanted people to have an understanding of the law before we turned again to a different version of the proposal that the sponsor has. And so I don't want to discuss that proposal right now, but we can have the sponsor, we're prepared to take up that proposal when the sponsor agrees to have it released. But I would like us to not go into the merits of it again, because I want people to really understand the legal framework before we take that on. Um, would you like to hear directly from the sponsor?
Sure. Yes.
Okay. Senator Hickman, can you please join us? And Senator Hickman, I'd ask that you give us a status update rather than going into the merits of your proposal, because we will very soon have that work session.
Thank you, Madam Chair. My name is Craig Hickman. I represent Senate District 14, which are 12 municipalities in southern Kennebec County, including my hometown of Winthrop. The question, Representative Lee, if you could rephrase it for me, so I make sure I answer it directly. Where are we? The Senator is correct. We have worked together with her analyst, Mr. Elias, to amend a proposal that you have already seen to narrow it down to 2 sections. That's where we are. And the senator informed me that because this was going to be a more of an informational meeting, the amendment was not distributed as I thought it might be, but that's because this is what the committee is doing on this bill today versus looking at the language of the proposed amendment, which may change after my review of the information in front of me as well, because some of this is, all of this is new to me. And I don't know if the Senate chair wants me today or at the next meeting to discuss some of the contradictions in practice that exist versus what is written down here. But that's up to the Senate chair. But there are some things that happen now that are not accurately reflected in this. And that's no disrespect to the analyst. It is just, there are things that we do that are not actually in line with what is stated in this ruling.
Senator Hickman, I appreciate that you've just been given a lot of new information as well. And so if we can hold off on that conversation until you've had a little more time with the information, I think that would be the most efficient and productive use of our time. Representative Lee, did you have another question? No. Yes, Representative Caruso?
So are you saying we can't hear from the senator on the practicality of what's actually happening so that we could be informed about that too while we're thinking about this ourselves?
So our role as a committee is to come up with a recommendation about legislation to the House and the Senate. And the bill sponsor has just been given a lot of new information. And I think that it is appropriate to let him digest this new information and then finalize his legislative proposal before, because right now we're kind of operating in a vacuum. We don't have that proposal. And to be fair to Senator Hickman, he hasn't had a chance to, again, look at his proposal in light of this information. So I think,
agree. I agree with what you're saying.
yeah.
That wasn't what I was asking though.
And so I'm sorry,
I
can
was
you
asking-
restate your question?
Yes. I was asking for him to explain his personal understanding of what is happening with the analysts, aside from what is written on the pages, that he is saying that there is a contradiction in what is actually happening. And I would just like to learn about what he means.
And I believe that that would be better discussed in the context of the concrete legislative proposal, because, we're not just a body that can kind of openly investigate the job performance of the OPEGA director. Our job is to evaluate a specific legislative proposal. And that's what this session was designed to help us understand the information related to that, and also to give the sponsor an opportunity to make any changes that he wished to his amendment before presenting it to us. And so I don't think it's fair for us to go into an inquiry about whether or not OPEGA director is complying with the law.
I just wanted to learn. I wasn't saying I was going to judge them, but
Yep.
that's fine. I have
But
another.
let me just respond, but that inquiry itself is from the perspective of the person who you're asking questions about is being broadcast and preserved indefinitely on YouTube. And so I think we need to be careful about talking about things that aren't related to the legislation, particularly when it's about a specific person. And I interrupted you. I thought you had a second question.
I did. It was my understanding from just discussions outside of the committee room about this, and it has to do with the Supreme Court decision. That there was also, and maybe this is what Representative Lee was getting to, there was also, they indicated that there is a need for changes to the law that is the only way there is a need for the legislature to look at the issues that are being discussed in this legislation. And so that this is a result of that decision, so to speak. I haven't seen the decision. I would like to read it so I could understand it. Is there a way you could send it to us?
Sure, I can send that. My understanding of that concurring opinion, and I did mention to Representative Lee, I'm going to go review that again just to make sure my understanding is correct, is not necessarily speaking, the court is not necessarily, and in this case, Justice Lawrence is not necessarily speaking that his opinion is that there's a need. I think what he is saying is that if the legislature feels there is a need, they have the ability to make that change. So separating out the court saying you should go change this versus you have the power to change this if you so choose. I think that is my understanding of that opinion.
Okay, thank you.
And Eli, thank you for sending that to all of us. When you send it to us by email, because I know it's a long document, can you just indicate the pages on which the court's opinion starts and then where the concurrence starts so that people can kind of get oriented to it?
Of course.
Okay, thank you. Representative Lee?
I can totally understand the idea of looking at the practical realities in the context of an actual piece of legislation. And so I'm perfectly fine with that. I'm curious from the bill sponsor when you feel, and I don't want to put you on the spot, but when you feel you can be prepared to present that to us.
As soon as it is scheduled. Yeah, as soon as, may I ask, Madam Chair,
Yes.
what is the deadline by which you must vote out bills that you received an extension on that were carried over from last session to this one?
So the deadline was the 30th of
Correct.
January, and we filed a memo with the presiding officers asking permission to continue to work on, I believe it was 8 carryovers. And we did receive that permission. And so there is not currently a deadline to my understanding, but personally, I think we should address this as soon as you have had the opportunity to digest this information and take another look at your language. And when you're comfortable with it, then you could let me know and then we will, I mean, ideally, actually, I would like to post it online so that people have a way to access it before the committee work session on that language. And so I'm thinking if you could give it to us by Monday or Tuesday, let's say Tuesday, then we could post it later next week and have another work session the following week or try to schedule it for next week. But I want there to be some public notice about the new proposal so that we get robust feedback on it.
I appreciate that, Senator Carney. In the VLA committee, we got an extension on 4 bills and the memo had a date on it. I think it's next Friday. So we know that we have to finish our carryover work by next Friday. So if there is a date, great, but the sooner the better. And so I will do my best to review all of this and revise the proposed amendment for this committee's consideration as early as Monday.
Okay.
And no later than Wednesday. Given
Let me ask,
the workload.
okay, thank you. Let me just ask Eli, because I might have missed a date. I'm not sure I saw the response to the memo. I saw the
There-
memo that went out.
A memo came out yesterday, I believe, with a number of deadlines that include, the committees, it's familiar with the legislative deadlines we have, kind of all bills voted, all bills reported out, et cetera. There may have been, and I apologize that I did not review it as carefully as I should have. There may be a deadline in that memo, and I can review it now if you want. That has for those approved carryover extensions, there may be an additional deadline in that memo as well.
Well, no need to apologize because I didn't review it that carefully either, but apparently Senator Hickman did. So thank you, Senator
Well,
Hickman.
I only reviewed the one that came to the Veterans and Legal Affairs Committee, of course. I didn't review the memo that you received from the presiding officers, but our memo had a deadline in it for voting out those carryover bills on Friday, February the 13th. And the new memo that your analysts have just referred to, we've also seen. And so we may have to adjust our weekly schedule for next week to ensure that we are complying with the deadlines that are in the new memo, which relate to all bills in the committee's possession, not just the extended carryover bills that were supposed to be voted out on the 30th. So
Okay, let me, so all bills have to be reported out by March 13th. I will take a look at that, but regardless of what the ultimate deadline is,
Yeah.
I think we should move this forward as quickly
Absolutely.
as you're able. So when you have a draft, could you please let both Eli and myself know?
yes,
And then we will schedule it for a couple of days after that, as soon as we can get it posted.
that's absolutely what I will do.
Thank you.
Thank you.
And I know that you've put a tremendous amount of work into this legislation. I just wanted to let you know how appreciative we are of your hard work.
I saw out of the corner of my eye, Representative Henderson may have had a question, maybe not, but I just didn't want to.
Let me ask
Thank
if,
you.
is there any committee member who has any additional questions for the bill sponsor? Yes, Representative Henderson.
I was just going to ask when the amendment would be permitted to be released to the committee.
As soon as it is drafted. Well, I will with haste update the current one as soon as I digest what's here. And anyone can ask me any questions in the hallway at any time, of course, between now and then. Thank you.
Any further questions, committee members? Seeing none, thank you very much, Senator Hickman. Are there any additional questions for Eli about LD 127? Any additional requests for information? Yes, Representative O'Halloran?
Just popped into my head. If this bill were to pass and the legislators and the Government Oversight Committee were to get all this information, if there was a lawsuit, would they then be able to be subpoenaed?
I think we need to wait until we see Senator Hickman's proposal, because
Okay.
right now we don't know what's the parameters are of what we're being asked to make a recommendation on. Anything else, committee members? Not seeing any. Is there a motion to table? Representative Kuhn,
Move to table.
is there a second? Seconded by Representative O'Halloran. Let's do this with a show of hands. All those in favor? And that is unanimous of those present. And so we'll close the work session on 127. And with that, we've concluded our morning work. So we'll return at 1 o'clock for our afternoon work session. Thank you, everyone.
Welcome back, committee members. You can return to the horseshoe. I'm going to open the work session on LD 1572, which is an act regarding prosecution standards for non-fatal strangulation or suffocation in domestic violence cases. I think we're going to have some proposed amendments handed out. If you can you just wait to start until we have all the materials? Thank you. We can. Would you like to go first, Representative Crusoe?
Good afternoon, everyone. I'm Elizabeth Caruso. I represent House District 72, which is much of northern Somerset County. Glad to have you here.
Good afternoon. My name is Ellie Sato. I represent House District 109 in the beautiful town of Gorham.
Hi, I'm Adam Lee. I represent House District 89. It's nice to see so many familiar faces this afternoon.
Good afternoon. I'm David Sinclair for the people of House District 50, the city of Bath.
Good afternoon. I'm Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Hanover, Milton, Roxbury, and my hometown of Rumford.
Hi, I'm Danny O'Halloran, and I would like to say that I appreciate all of the hard work that our guests do on a regular basis in here in this room. And I represent District 20, which is the majority of the city of Brewer.
And I'm Amy Kuhn. I represent House District 111 in the town of Falmouth, and I serve as the House Chair of the committee. Senator Hagan, do you want to introduce yourself?
I do. It's pretty choppy, so I might cut out. I'm Dave Hagan, Senate District 10, many towns surrounding Bangor, not Bangor. Thank you.
Thank you. Right ahead, Janet.
So just to remind everyone where we are, last week you had a work session on this bill in response to language proposal. Let me back up. Last year, this bill was brought before you. It had many different moving parts about dealing with domestic violence and non-fatal strangulation and suffocation. And you asked the Maine Commission on Domestic and Sexual Abuse over the interim to look at precisely the issue of strangulation and suffocation offenses, how they should be listed in the Maine revised statutes, how they should be defined, where they should be located, etc. And they presented a report to you earlier in January. And then last week you had a work session based on the language that they had proposed to use to amend the aggravated assault statute to separate out the crimes of suffocation and strangulation. CLAC did not have an opportunity to meet to talk about that proposal until we were actually talking about that proposal. They were meeting at the same time. So since then, they have submitted what you now have on the salmon paper, which is their comments on that proposal, which came from the Abuse Commission report. So that's one of the handouts in front of you. In addition, last time you spoke with District Defender Logan Perkins, as well as domestic violence advocates, and there was not an agreement on how to move forward. They had different concerns about the way that the proposal was written. So you asked them to talk to each other and see if they could reach an agreement. It's my understanding that they have tried really hard, but perhaps an agreement wasn't possible. So we have representatives from MACDL here today, from PDS. We also have representatives from the Maine Prosecution Association, Maine Coalition and Domestic Violence, and a safe nurse that are here. And it's my understanding that the defense attorney side would like to explain their concerns to you. And then the Prosecutors Association and Maine Coalition and Domestic Violence have two different proposed approaches, understanding that there wasn't agreement with the other folks for how you might move forward if you agree with the proposal that they have. I think that's everything.
Okay, thank you for that explanation. I guess I'll invite one of the defenders to come up. Do we want? Like it's Mr. Morgan.
Good afternoon, everyone. Thanks.
Welcome.
Thank you.
Could you start by introducing yourself?
Yes, thank you.
Thanks.
Representative Kuhn, members of the committee. I am Matt Morgan, the current president of the Maine Association of Criminal Defense Lawyers and a private practice defense attorney here in Augusta at McKee Morgan. I appreciate the opportunity to present here at the work session. We were not able to have someone come in time for the last meeting, so this is very helpful from our perspective to be able to be here and address you. I passed along now and sent earlier a set of jury instructions, an excerpt rather from a set of jury instructions in a case that deals with the issue that's before the committee from Mackerel's perspective. And in particular, that's the issue of whether or not strangulation alone is sufficient for determining and under the law as it currently exists, whether an aggravated assault has occurred or whether it must be strangulation in the context of extreme indifference. You'll see from that proposed jury instruction, which was then read by Superior Court Justice Dan Billings, that the parties agreed and he instructed the jury that extreme indifference and strangulation each have to be given to the jury as an instruction. And that makes sense when you read the statute as it presently exists. It includes language such as includes but not limited to strangulation when explaining the number of things that a jury could consider for extreme indifference. And when it goes on to define strangulation, it uses the language for purposes of this paragraph, meaning the paragraph discussing extreme indifference.
Could you-
Yes.
Could you, first of all, could you indicate to us what page and line
Oh,
you're
yeah, I'm sorry.
referring to? Was that your question?
Going too
Yeah,
fast.
if you could just walk us through it a little more slowly.
Of course. It's Friday. I'm trying to go faster than I should. So
Before you do that, I just want to say you can see the actual paragraph of current law in the handout of the two proposals. Just so that you have the current law in front of you. So it's 208(1)(c). Yes, the proposed amendment would change that, but you can see what the existing language is to put the context of the jury instructions he's going to talk about.
Great, thank you.
Janet. If you look at the handout, you'll have the trial part listed and it's pages 9 through 10 that you really want to look at. And it starts in count 1 that has to do with the aggravated assault. And if everyone would like, I will be quiet and let you all read for a few moments.
Thank you, appreciate that. All right, looks like we're ready to go. I'm just gonna let him finish first and then we'll go to questions.
And that, I wanted to give the committee the actual transcript so you could see how that was delivered by the judge. I think an easier place to read this, just in terms of the visuals, is the second piece I gave you, which is what was proposed by my partner, Walt McKee. This is the proposed instruction, and aside from a couple issues, I think where the judge basically just used a different, word here and there, this was what he read. And I think it's easier to read here. And what's key is that there's a specific set of language here that says, yes, you may consider strangulation, you may consider it as a possible way of demonstrating extreme indifference to the value of human life, but you must find beyond a reasonable doubt that the acts were done with extreme indifference. So that language in the statute was not removed simply because the state was presenting evidence of strangulation. The state's allowed to say strangulation is a way we can prove extreme indifference, and we can all imagine facts where that would be easily done if someone's being strangled, that they could be killed from that. But the idea here is that that language, extreme indifference, is to be included with the jury instruction. And if you look at the statute, the reason that makes sense when I started is there's a couple key phrases. Turning to the green handout under 1C, you can see where it says, circumstances manifesting extreme indifference to the value of human life. And it goes on to say, such circumstances include, but are not limited to, and then it includes strangulation. So that's not saying it replaces extreme indifference. It's saying that's one way you can demonstrate it. And then to make it more clear, the statute goes on to say, for the purposes of this paragraph, strangulation means the following. And what that's saying is that for the purposes of defining extreme indifference, this is what strangulation will be. It's not saying you can do away with the extreme indifference. It's saying, here's one of the non-exhaustive factors we've given you that you can consider, and here's how we're defining it. So that's the statute, and I've reviewed the testimony from CLAC. It appears to be an agreement that language is part and parcel, so to speak, of the law, and that separating it out is something CLAC opposes. I understand the Saussure decision was discussed some, and part of the reason I wanted to give the committee jury instructions is that Saussure was a bench trial. Justice Anne Murray in Bangor was the presiding judge, brilliant judge. She doesn't need lawyers to tell her what the law is. She knows what the law is, and that opinion doesn't say that strangulation and extreme indifference are two different things. It just says that she reviewed the evidence and she determined, in this case, strangulation was sufficient for the state meeting its burden to show extreme indifference. And I would just finish by saying why it's important that strangulation on its own is not sufficient to prove extreme indifference. And I know that Executive Director Terrapinian may address this more with the committee, but this is a Class B statute. That's a very, very serious statute. It's up to 10 years in prison. There are many other statutes the state can pursue for domestic violence offenses, which MACTL acknowledges are serious and important to be prosecuted. And in this instance, if extreme indifference is removed, it means cases where people may be pushing and a hand goes from the chest and up to the neck could be enough for a Class B. Cases where someone might have a tie on and that tie gets pulled, or a shirt gets pulled and someone's choked, could be enough to have someone look at a very, very serious felony when the intent and circumstances don't demonstrate extreme indifference. So the laws that exist, those cases can be prosecuted appropriately. They shouldn't be prosecuted as Class B crimes unless it's the kind of strangulation that shows this true extreme indifference. So that's, from our perspective, policy-wise, why it's important. But we certainly believe that the law requires both to be proven, and that's why we wanted the committee to see those jury instructions.
Okay, thank you for joining us today. Let's see if there are questions. Representative Lee?
Thanks. I guess I'll start with this question. I think I have several, but I'll start with this one. I'm looking at the current statute in sub C, where the use of strangulation is preceded by the word or. And I mean, I think there's multiple readings, right? One reading could be that or is disjunctive, and as a result, you can either prove extreme indifference to the value of human life and bodily injury, or just strangulation. The other interpretation seems to be Justice Billings' interpretation, which is you still have to prove
extreme indifference, and you have to prove bodily injury, and strangulation is just one way to do that. Has the law court chimed in on that question at all?
I don't know that that specific question has been addressed. I think one reading of Saussure, which is a fairly brief decision, is that it's a multi-factor analysis of that in that instance, because they go through some of the facts, right, that led up to the strangulation, and they say that those facts allowed Justice Murray to find that there had been extreme indifference. So I view it as a non-exhaustive list. I think Clack addresses this in its written material to the committee as well, and makes the point that it very well may be in the interest of prosecutors to charge cases that way, because there are multiple circumstances and it's easier to add those together to get to extreme indifference. That's from the prosecutor's perspective, not ours. But I certainly view the second reading as being the more appropriate one, especially given the context of the Class B charge and what it's meant to achieve.
Yep, go ahead.
Do you have the citation for the Saussure case?
I have it. One moment, please.
And I don't know if you have your abuse commission reports, but it's one of the appendices to that report. It's in.
2015 ME 144.
Thank you.
This is the abuse commission report, which is probably in your folder.
Looking in the wrong folder.
I'm sorry, which exhibit is it?
I don't remember. I only have excerpts of the report here because of the. But it is attached. I remember reading it. Appendix
Here we go. Yeah, appendix D.
D as in dog.
Okay. Are there any other questions for Mr. Morgan? Yes, go ahead, Representative Caruso.
Oh, my bad.
Thank you for being here. And, while you were speaking, I was trying to understand how strangulation could not be extreme indifference to human life. What case could that ever be? But then you explained some examples, such as someone pulling someone's tie. Are you aware of anything brought in a court of law where someone had a case that someone hurt them because they pulled their tie?
That was an example I gave right now, thinking of myself. I'm certainly aware of cases where people have been in a pushing match, essentially, which I hope we can all agree isn't a kind of 10-year prison case.
Right.
And there then becomes a question about, well, whether their hands ever touch someone's neck, and then how long. And if the definition allows that brief hands on neck is enough. And, these cases happen in fraught circumstances where people are upset. It's difficult to know what happened. We don't have video evidence. So those kinds of cases are regulated, and they're often dropped down from those Class B felonies, but to bring them in the first place is unfair to a defendant under those circumstances. So those kinds of cases are brought, yes.
So in the discussions that the different groups had since our last work session, did anyone try to have another definition or another way of clarifying this so that it would be, so that situations like that would not fall under this? Another way of.
I think we are going to see a proposed alternative amendment after we're finished. Is that your question?
Yes.
I'm happy to answer that. That specific issue was not addressed. I think it would be very difficult to capture that whole universe. It's kind of the way laws, particularly I think in the criminal justice context, are written is fairly broad, so that when the court gives instructions, different fact patterns can fit into them. It would be a long list, I think, if we tried to do that. But it was not specifically discussed. No.
Representative O'Halloran?
I also am struggling with your examples. Because I mean, it's been stated that they have to have expert witnesses and stuff like that. And just the thought of choking somebody with a tie, I mean, you would have to really put some strong effort into that. And just somebody's hands coming up briefly also would not meet that standard. I mean, they all have to meet a threshold. So part of me sitting here listening to your examples makes me think this is exactly why we need this language in this bill. But can you explain that? Yeah, I'm just
Sure.
not sure that I understand those examples.
Yes, so one of the experts sometimes used by the state in cases like this is Polly Campbell. And we've subpoenaed records from her, and the definitions of strangulation and the kind of force she describes can be frankly very minimal. That's one of the emphases that this testimony tries to put forth. And we don't agree necessarily with that expert testimony, but that's something the state has been able to put forth. I believe she talks about how the amount of pressure to pull a trigger, as an example she gives, is the same amount of pressure that could be used in a strangulation case. So there is a very broad range of cases from the perspective of some experts.
Representative Lee?
Have you seen Clack's testimony from today or their proposal from today?
I have, and I read it quickly before running over here. So yes, I have.
So I think what you said earlier is accurate, that they sort of say, don't change the structure of the law, but they also are fine with an inclusion of suffocation. Do you have a position on whether or not that makes sense?
I think similarly to Representative Caruso's question, my concern is that we have a statute that's broad enough for the state to argue extreme indifference when it's appropriate. And if we keep adding specific circumstances to that, we will have a very unwieldy law. I think the state can and currently does bring suffocation cases. And then it can say that if a person is covering someone's mouth and they can't breathe and they pass out or they urinate, or some of these facts that we know tell us it was really extreme, then they could bring that without the suffocation language being added. MACTL's concern is that as we add this laundry list, the law becomes more and more unwieldy.
Any other questions? All right, thank you for joining us.
Thank you all.
Prela Tarpinian, did you also want to come forward?
Thank you.
Welcome.
Hi, good afternoon. My name is Freyla Tarpinian. I'm the Executive Director of the Maine Commission on Public Defense Services. I'm going to beg for a little bit of patience, and I would like to give you my full background because I think it's informative to this discussion. I have been a practicing attorney for 20 years, coming up at this May. I started private practice doing criminal defense and family law for about 7 years. I then joined the prosecutor's office as a domestic violence prosecutor in 2013. I was on a prosecutor grant. I did that for 10 years. I led the SADV unit starting in 2015 for Kennebec and Somerset County. I ended my career as a prosecutor as the deputy DA, still the main prosecutor for Southern Kennebec cases that included instances of all felony DVs, sexual assaults in this area. So I have personally tried as a prosecutor a number of strangulation cases. I then, as you are well aware, changed over to become the public defender or lead the public defender's office in the state and capital region, where I had the opportunity to lead a team of individuals who has defended a number of strangulation cases. So I think I bring a very unique, nuanced perspective to all sides. I have used witnesses and expert witnesses on both sides of this equation. I've used the statute intimately. The statute has changed in the course of my career in terms of adding strangulation into it. And I've watched and personally interacted with the statutory changes as they've come through. I would like to clear up a few things. So State v. Saucier does have language in it that indicates that strangulation is a factor to be considered, and that if a victim testifies that the use of strangulation happens in the course of an assault, there is enough evidence in that case to find that a Class B aggravated assault happens. A person, a judge or a jury, a trier of fact may find that. That is permissible use of the statute, and that happens regularly. It is not a must. So Representative Lee, you asked if there's multiple readings. There are multiple readings, and the law of leniency says that when there are multiple readings in a statute, it goes to the defendant's because of due process, it goes into the defendant's favor. So the most lenient reading of the law matters. There are cases happening all the time right now, as recently as that I'm aware of is November of 2025, where the instructions that are given to juries in this state, in Skokie and Somerset County specifically, in the Eric Bickmore trial, that the jury may find the manifest indifference to the value of the human life using all of the list of factors that are in the statute currently and strangulation as a potential indicator of manifest indifference. It is not a straight line. That strangulation is manifest indifference. There are some jury instructions that I have seen that do suggest that there is differences. And I would suggest that there's really good policy reasons not to make it that easy to prove strangulation. Strangulation is incredibly dangerous. I have done trainings. I have personally trained law enforcement officers on investigating and prosecuting strangulation. The reason we care so much is because it is so dangerous. Strangulation is absolutely fatal. There's no question about that. The problem is the suggested language in the amendments that you're going to hear broaden the definition of strangulation to the extent that incidental conduct is brought into it. So you asked about Representative Crusoe, specific examples. Yes, I have defended cases where a person grabbed a sweatshirt of another person and yarded them back. Not appropriate behavior, criminal behavior, but that was used as strangulation because there was a momentary in that where the tie of that sweatshirt came across the neck and the person testified that they weren't able to breathe. That is incidental contact. That was not a successful prosecution, but that was charged and prosecuted and defended as a Class B ag assault. That is incidental contact. That falls within the definition that's being suggested. The value of having a jury consider strangulation, and there is value in emphasizing strangulation. If you're interested in ensuring a good, proper prosecution and using strangulation and recognizing its seriousness, putting it in the statute has value. Putting suffocation in the statute has value. I'm not gonna like try to flip my hairs. I'll be honest. Manifest indifference without human life. If you prove suffocation, and when we're thinking strangulation and suffocation, we're thinking somebody sitting on top of somebody else and holding their nose and mouth so they can't breathe, trying to stop them from breathing. That is serious conduct. I'll defend it if I'm a public defender, and that's my client's been accused of it to the full extent. But I will tell you as a person testifying with legal language that I've trained people on the dangerousness of that behavior. That behavior is dangerous. That's the reason it's in the law. It's a very serious consideration. So the value of making sure that the law is clear and making prosecutors demonstrate manifest value of indifference to human life is ensuring that incidental conduct doesn't get brought into it. So my children fight in the backseat of my car every time I drive them anywhere longer than 20 minutes. There's plenty of suffocation that happens back there. It's not a Class B aggravated assault, nor should it be. And if it's adults doing the same behavior, that's not okay. I'm not here to say that that's okay. It's not. But there's a statute that's in our law that will allow it to be addressed appropriately. A Class D domestic violence assault with 2 years of probation, an emphasis on certified batterers intervention program, and possibly up to a year in jail, may be an appropriate response to someone being yarded by a sweatshirt or somebody who's having this incidental contact. So somebody's in a room, getting out of the room, there's a tussle. I'm not saying that's appropriate behavior. I'm saying that before we put someone in prison for up to 10 years for that behavior, we need to be really convinced that that behavior is dangerous. There is a lot of experts out there on strangulation. Polly Campbell is one of them. We have lots of transcripts on what she'll tell you and inform a jury about strangulation. And they will tell you there's 32 signs and symptoms. It does not take a whole lot of effort to strangle somebody, unfortunately. That's why it's so dangerous. If it was hard to do, it would be less dangerous. But if somebody is seriously pinning somebody up against a fridge is a common one, down on a bed is a common one, with the thumb pressed into someone's throat and stopping them from breathing, or if impeding blood requires usually you to pass out. But to the extent that you're losing control of your bodily functions, the jury you have a statute that permits that to be taken seriously, and it should be taken seriously. There's value in that. The concern is that there are occasions where people are charged with incidental conduct. A push in a doorway, again, is not acceptable behavior, but it should not be treated the same as somebody trying to murder somebody else, which is what they'll tell you what strangulation is, right? It's somebody trying to kill someone else. We don't use attempted murder because it's a difficult statute to work with. So we want to recognize the value and the use of that behavior specifically as a significant factor in ag assault. But before we put people in prison for 10 years, we should be ensuring that the statutes follow what is happening. And so incidental conduct should not be accidentally brought into this. People, somebody who just, that's not okay, but that's not trying to kill somebody. And it shouldn't merit 10 years in prison. Maybe it should merit a misdemeanor. And I think I leave that into the sound discretion of prosecutors and their DAs to decide how to proceed on those cases. But the opening up and the vagueness of these definitions really open a door that I'm very concerned about. From a PDS standpoint, it's going to cost us a lot of money to defend these cases. If every time if these cases open up to an extent where we have a lot of incidental contact, that's expert witnesses that we're paying for, that's thousands of dollars a case, that's fees that go up because these cases take longer, people are in jail longer, the cost of this, it gets driven up. And again, I am not here testifying that we should not take domestic violence seriously. That would be a betrayal. I started as a crisis counselor when I was 20 years old in the ER doing intervention with domestic violence cases. I take domestic violence very seriously, but I think we need to be really careful about making it so broad because we care about protecting people who are subject to abuse, that we don't bring in anything, because there's a danger there too. And the danger is people get put in prison for decades for conduct that is not warranted. You have tools in the law right now to address that. You have serious bodily injury. If and when that happens, strangulation doesn't usually lead to that. I mean, the experts will tell you it does, like neurologically. That's hard to prove. I'm not going to say that it's not, but it's there if you can use it. And there is also a substantial risk of death. You have experts that will testify that the use of strangulation and suffocation is a substantial risk of death. And you have another prong of ag assault that's available to use. You have multiple theories existing in law right now that are sufficient for this. So in November of 25, Eric Bickmore was convicted of DV strangulation. It's a class A based on priors. So the statute is not unworkable. It's being used effectively every day.
So you're opposing any change, including
oppose-
not adding suffocation?
I'm
you're
neutral on whether you add
agnostic?
suffocation. I
Okay.
think if you add it as a factor to be considered, there's a legitimate reason for that. So I'm not pro that, but I'm not going to testify that would be
Understood.
a terrible idea. If you're interested in emphasizing suffocation same way you're interested in emphasizing strangulation, that would be a manner that would ensure that the prosecutor still has to prove that the behavior that is used warrants the result.
We've got a few hands up. First, Representative Caruso.
Thank you. Thank you for that clarification.
Yeah.
That's very helpful. Have you seen clacks?
Yeah.
And do you see how they added or suffocation and it's still with regards to extreme indifference to the value of human life?
Yeah.
And this would satisfy your concerns?
I think my concern is making it too broad. And so making it like, if you use this, then that happens. Yes. If you are interested in emphasizing suffocation, a way to do that would also ensure that a jury still has to consider the behavior, that would be a way to do it.
But what you are, can I?
Go ahead. Yep, you can have another.
But separating it into C and D, but including bodily injury and manifesting extreme indifference of human life, would that?
Yeah. I think as long as you can make it a factor, you can.
Extreme indifference.
Yeah, I think that the key is making sure that it's understood that it's a factor to be considered.
Yes.
Which I think is, and I do believe there's different jury instructions. I'm aware of different jury instructions.
I think
there are.
it was.
Representative, okay,
Yeah.
is this just a follow-up?
Yeah, it was my understanding that there was a need to separate them into two different paragraphs, but if there was still extreme indifference clarification on both strangulation and suffocation, it would
It would allow
satisfy your-
successful prosecution.
Yes.
I think the reason that my understanding, the reason to separate it would be for data collection, which I'm very confused by. I compiled domestic violence statistics for the prosecutor's office for years. They use computers to charge cases. They are absolutely able to click a button when it is a strangulation case or a domestic violence versus a regular case. Because right, there's two types of aggravated domestic aggravated assault. I only did domestic violence, but there's two types, right? There's absolutely within a computer system the availability to flag whatever type of case you're trying to collect. I ran statistics for years on these cases. So the idea that for suffocation. For the judges, I do believe they use sequence numbers. So your sequence numbers are going to be the same, but the idea that the only way to collect this data, that's ridiculous. Prosecutors have to file a complaint. They know when they're filing the complaint on this theory.
All right, let's go to some other folks, Representative Lee and then Representative Sinclair.
I want to probe a little bit the discussion about the different jury instructions that are out there. Are there, so we have the Lee one.
Yeah.
The Lee one seems to be, I don't know, if you were to create a continuum of ones that are no disjunctive or and yes disjunctive or. This seems like on the clear end of the no disjunctive or. Are there instructions that sort of do make that straight line?
Yes.
Okay.
There's two categories of instructions that I'm aware of personally. I don't know of a third. They either include strangulation, that the use of the factors or the use of strangulation, and they have to add language to the statute to do that. They have to add the language or the use of strangulation is that. Then there's the other jury instructions, which are the ones that I'm the most familiar with. So in Kennebec County and Somerset County, which is where I've practiced most recently, for like the last 13 years, I've only used jury instructions that use them as factors. So I know, but I've heard, and when I was a prosecutor, I was trying to get it the other way because it's easier to prosecute.
Follow up?
Given that what I would say pretty wide variance in the interpretation of the statute, I would imagine there'd be more active litigation on this to the point that we would have a meaningful decision from the law court. And am I being naive in that regard, or?
I am ever hopeful for clarity from the court, like all the time. And they provide it when they get the opportunity, right? But you know the statistics on prosecution, you know the statistics on the number of jury trials we have, which are very few, and even fewer get appealed. So the opportunities for this are not as robust.
Representative Sinclair.
I appreciate hearing that mine aren't the only kids who have trouble with the 20 minutes or longer car rides. In your many years as being the lead DV prosecutor for Kennebec and Somerset, did you at any point, or do you recall at any point, having a case where you had charging difficulty or proof difficulty in a case that you strongly felt was an ag assault, but was premised on suffocation?
No, I never charged a case based solely on suffocation. That's not something that I ran into a lot. It's not something we defended a lot. Strangulation, yes. Suffocation, we saw it occasionally, but it was usually wrapped up into a larger event. So you don't usually just see suffocation. You get to the point where you're in suffocation, it's usually someone being pinned down because it's hard to suffocate somebody who's not incapacitated to an extent. And then it's usually part of a larger fact pattern. And so there's a lot of charges. When you have a number of events, there's a lot of charges that can be generated out of that kind of event. I've never personally prosecuted a suffocation case. And I prosecuted a lot of domestic violence cases for a long time.
Right. Yes, go ahead.
And just to quickly turn to one of Representative Lee's question, do you think the reason why we haven't seen a lot of appellate activity in this space may be because since there is ambiguity in how we, the legislature, have worded the statute thus far, a lot of these are being brought as ag assaults and then bargained down to the misdemeanor assault that we perhaps all agree the index amount was?
So I'm going to do something dangerous, which is I'm going to work on my memory, which I don't usually do. I like research. My memory is the statute changed to the inclusion of strangulation in the around 2015, give or take. It's in that general area. If you look at the last 10 years, 5 of those years had COVID and very few jury trials. So you're looking at a period where we don't have a lot of development of appellate law with a law that was relatively recent. So I know I tried a few cases. I think 2017 was like the first time I tried a case went all the way through strangulation. We did use it. We did bargain a lot, especially if you had the C. If you have a prior strangulation, you can get to a felony level and you can accomplish a lot of the reasons you're prosecuting that way. So there is a lot of plea bargains. Again, what I said, Representative Lee, with the statistics on cases that actually go to trial, the numbers are just very small. So there's a lot of plea bargaining that go on, but there are people who also plead.
There are additional questions? Okay, not seeing any. Thank you.
Thank you very much.
All right. Should we, let's see, we'll invite Shira Burns or Andrea Mancuso.
I just want to apologize. For some reason, proposal B is stapled on top of proposal A. So hopefully when they talk to you, not that you're dumb, but I just feel. I mean, it makes sense to me to state with it too.
Welcome.
Good afternoon, Andrea Mancuso. Professionally, I am the Public Policy Director for the Maine Coalition to End Domestic Violence. And on this bill, I'm the proxy from the Abuse Commission. We had, at your request, had a conversation with Attorney Firkins from PDS and Attorney Morgan from Magdal earlier this week, at some point since your last work session. And as Attorney Stucco has relayed, we were not able to reach consensus on any modification to the statute. But we worked with Attorney Burns to try and bring forward a proposal that addressed what we heard were perhaps the most consistent concerns from the committee member in the last work session, and wanted to give you some additional proposals to consider that would still advance the policy goals of the Abuse Commission's report. And so proposal A, which I think is the second page, has a structure like what Senator Carney had proposed in the last work session. Both of these amendments, the two issues that we were trying to address that the committee discussed were keeping bodily injury in the language and removal of the application of pressure to the chest. So proposal A continues to do that, separating out strangulation and suffocation. Proposal B instead puts both of those into the same paragraph, which I think is largely responsive to some of CLAC's feedback around unanimity.
So in neither case is the extreme indifference standard held as a separate additional element.
That's correct. I think where the lack of consensus comes in large part from is the jury instructions that were provided to the Abuse Commission's working group were all jury instructions that are not like the ones you've seen today. I mean, it would have been impossible for us to collect every jury instruction in every strangulation trial. I believe Attorney Burns asked for jury instructions from her peers, and those are the ones that we were provided. So I also read the Saucier case that if you prove strangulation, you have proved aggravated assault. And there's no mention of the need to additionally have a finding that it manifests extreme indifference to human life. So that's, I think, okay, where that's what the Abuse Commission discussed and recommended. And so as the point person from the Abuse Commission, I think that's what we would continue. Where we continue to land is that it does, in fact, serve as a circumstance that manifests extreme indifference to human life.
All right.
I think the law court has.
Let's see if there are questions. Representative Sinclair.
Thank you, Madam Chair. So are you arguing that as a matter of law, strangulation alone is proof of extreme indifference? I read the case instead to say that it can be. In other words, that it was an error for the court to have found in that circumstance that it was.
I think the court case says if under our current law, if the state proves the elements of strangulation, that's sufficient for an aggravated assault conviction. And I think that's the conclusion that our amendments carry forward.
Representative Lee.
Yeah, I've been reading Saucier because and you can read the statute both ways, and I actually could read Saucier both ways. There's a sentence that I think you're citing, and I think it's, again, I think you can definitely make the argument. It says the statute includes strangulation as a circumstance that manifests extreme indifference to the value of human life. And
Paragraph 8.
and like, I
It does.
definitely, well, I can see that a reading that says that means ergo strangulation equals extreme indifference towards human life, but it's the use of the word circumstance that I'm sort of like mulling what Justice Jabber meant by using the word circumstance there. Because that could be like just saying, if you read the list of bodily injury, he could just be saying that's another circumstance that's demonstrative of that bodily injury that would include extreme indifference. I'm no closer to having a conclusion one way or the other.
Do you have a question?
No.
Okay. Thank you for sharing. All right, are there?
I will say,
other
we
questions?
acknowledge that what we're asking you to do requires a policy decision. We think the policy supports that. I would also just note that one of the medical experts that the Abuse Commission consulted, Carrie Capaldo, who is the safe nurse at St. Joseph's Hospital, is also here today in case she can be of any use to answering any of the committee's questions. And all tutorial questions should be referred to Attorney Burns.
Thank you for joining us. Shira Burns, would you like to join us at the horseshoe? Janet, yes.
It's all right, I'll wait. So the difference between here and here, right?
Yes.
Is that,
Sorry, Representative Cursor, are you holding up A or B or both?
so A and B both,
Yeah.
they're both separate from C. So whether they put D and E separately, it's still separate from C. And when they put D and include suffocation and strangulation in one paragraph, it's still separate from C. So neither one of these options are requiring that the act of strangulation and suffocation happen to, in that case, manifest extreme indifference to the value of human life.
Correct.
Right?
Right. I think that's what Representative Lee was saying is a different interpretation. I think that they would argue and have argued that doesn't change the law except adding suffocation. But it just depends on how you read that final paragraph of Saucier.
But the example that was been discussed over someone pulling someone with a sweatshirt. The reason why the only way that person would be saved from a Class B crime is if it's all under the indifferent, it's manifesting extreme indifference to the value of human life.
I think that's a hard question for me to answer. Maybe a different person could answer it. But I think paragraph 7 of Saucier is actually interesting in that regard as well. If we need to print more copies, we can. It's in the Abuse Commission report, which may or may not have found its way into that.
You're talking about this?
Yes.
Yeah, Appendix D.
Can we have a second, Mr. Regan?
Yes, that's fine. I'm sorry, Representative? Oh.
I have a copy of the Abuse Commission's report with Appendix D, but my copy only goes to paragraph 5.
Is there nothing on the back?
So the back page is a graph, and then the other page is Appendix F
Oh,
for my copy.
we'll get you another copy.
Okay.
Yeah, I can read those aloud while you're getting it copied if you want, or no? So I don't know if this answers your questions, but I just want you to know what the Saucier language is, and I think there is a dispute over how you interpret it. I'm not going to disagree with that, but Paragraph 7 says Saucier, that's the defendant, contends that the evidence was not sufficient to support a finding that he assaulted the victim under circumstances manifesting extreme indifference to the value of human life. He argues that the strangulation incident did not demonstrate extreme indifference because it only lasted for 8 seconds and did not constitute, quote, strangulation within the meaning of the statute because the victim was able to talk and yell while she was being strangled. And the court disagreed, then going through the language that Representative Lee said, which is that, so starting the beginning, paragraph 8, the section that's C in current law, plainly defines strangulation as an application of force to a person's throat or neck that's sufficient to impede the person's breathing or circulation. The statute includes strangulation as a circumstance that manifests extreme indifference to the value of human life. Here, the victim's testimony supports the court's finding that Saucier applied enough force to force the victim's neck to impede her breathing. Force to the victim's neck to impede her breathing, and that evidence is sufficient to support Saucier's conviction for aggravated assault. So I think aside from the question of whether the current law, like this is a change or not, I think that's not something we can actually answer that is disputed. I think I would propose to you that maybe just think about what do you want the law to be and make it that way. Does that make sense? Like whether this is really a change or not, I don't think you're going to get all the people in this room to agree on that. But if you want that to be enough, then take it out of that paragraph, won't be harmful. But if you think that's not appropriate, you want it to be one of factors, then the proposal that CLAC gave may work, although depending on who does the statistics, whether that helps with data collection or not. I'm only familiar with the way the judicial branch does data collection because I used to work for the judicial branch. And I know for their data collection, having it in a different paragraph matters. But it sounds like that may not be the only possible way to get this data. So I would defer to the people who know that better.
All right, Director Burns, can you join us, please?
Sheriff Burns, Maine Prosecutors Association. Can I just think out loud like Representative Lee? Because I also
Right. Did you have any remarks you wanted to share?
I mean,
Or it's all been said.
yeah, I mean, today was really enlightening. I will say, we've been working on this through the commission for a year. My first step was to get jury instructions, and it wasn't because I thought there was any ambiguity in the law. I've practiced this. I know what I've argued in closing. I know what the judge's jury instructions are, and I know what we've argued about. I thought I had this clear picture, and I got a lot of transcripts from other counties. And they were all consistent with my experience. And the reason I was collecting the transcripts is not because I was looking at what the judge was saying in regard to, do we have to prove extreme indifference and strangulation? I was collecting them because we were trying to make the point of how cumbersome they are. And they're really hard to understand. Jury instructions go on forever, and would be simplifying them be helpful, more clarity for juries. In the ones I collected, which was Somerset County, York County, Cumberland County, Androscoggin County, they were all consistent that the judge does not do that extra language that's in the one out of, I think it was Wiscasset. I will say I read it for the first time right over with some prosecutors, and all of our mouths dropped like, wait, this is happening? No, didn't know. And no one said anything. I will say, I shouldn't say no one said anything. I do believe Megan Maloney's district mentioned this a while ago. I think before I even took my position, we had like a statewide group, and we said, oh, just show them saucy, argue saucier and you're fine. It's not be a problem. And it never really amounted to more than that. So, unfortunately, this is a problem that we do have this split. But what I absolutely want to say, respectful to my colleagues, this is really hard to prove. And the examples are given, and you send them away for 10 years, 2 decades. I'm sorry, like strangulation is very hard to prove. Everything is proof beyond a reasonable doubt. You're proving every element of the crime. Look at all the jury instructions about intentionally, knowingly, recklessly. You have to prove the impeding of the breathing or circulation of blood. I've talked about it so much of how hard these cases are to prove. I cannot envision you changing the paragraph that it's in, and suddenly we get all these strangulation people, and then we also send them away for 10 years. That's not, I pulled every single law court case that had the word strangulation in it. And it's the sentences, some of them were because there was a lot more conduct going on. But we're not even getting to 10 years. So I do think that it's not consistent with what we are seeing statewide. And we had been talking about this. We came together to really look at it, also about the suffocation, about the need for it. There is different practices depending on what part of the state you are, like how much suffocation you need to get to extreme indifference to the value of human life. And we really listen to the medical perspective of that, that it's so synonymous to strangulation, there really isn't the policy difference. So
Let's see if there are questions.
thank you.
All right. Representative O'Halloran.
Thank you. Giving a comment that was made at the opening, and I apologize, I can't remember your name, about one of the experts testifying that it takes a little bit of like a trigger pulling a gun. If you know what you're doing, or even if you don't, there are spots in your neck that you can actually make somebody unconscious. I mean, people have died from that move, and that does not take a lot of pressure in that sense. But if you're, physically, it's a little bit different, but you have to get the right spot in order to have minimal pressure. Is that?
I mean, we do have Carrie Capaldo here. I would say she would be the better expert for that. You have your carotid, your jugular. Those are the two, and those how the asphyxiation can occur when you put up, occluding the carotid or the jugular. But no matter what, you have to put these cases in context of what is actually occurring. And, we hear like, oh, someone grabbed their necktie, and someone brought this to the attention of the police. Someone called 911 and was scared. I mean, there's so much more context than, I think we heard, and I know Janet said it, obviously with the parent and a child, it's different, but like, oh, they just moved their hand over the mouth. There has to be more to the story. And again, prosecution is hard to convict someone. I also we could analyze the statute as much as we want in the sense of, oh, you had this happen and you could charge this. Look at every crime. Look at domestic violence assault. To convict somebody of domestic violence assault, intentionally knowing or recklessly causing offensive physical contact. And that means a reasonable person would be offended by the contact. That can get you domestic violence assault conviction. So it's literally not bodily injury, but if it's offensive physical contact. All of our statutes are made up in a way that people can think of situations that they would think that this would be inappropriate to charge. That's not uncommon. We do have prosecutor discretion, we use it, and we have to look at the whole context. What we know about strangulation and suffocation is it's very dangerous. There's very good policy reasons to hold these people accountable for their actions. I would love to get 10 years on them. I don't know if we do, or in most cases we don't. And then also I don't know the statistics on suffocation, but strangulation. This is a very dominant crime, used men strangling women. We know the domestic violence, it's usually perpetrated by men, not always, but strangulation is actually even way higher than domestic violence assault.
I just have one quick follow-up.
Okay.
Is it true that more than half of the homicides in the state of Maine are from domestic violence?
So the domestic violence homicide review panel just came out on Monday. I don't know who went to the Hall of Flags to go see it. And so it's domestic violence related. And did that hold true this past year? Yeah, it is. And I know Yes, and it is, and I'll say the Domestic Violence Homicide Review Panel report again singled out the use of strangulation as being a precursor to homicide.
I was just looking at that. Yeah, thank you.
Are there other questions, Representative Lee?
I'm gonna ask you a question, and if you don't know, I might have to call Matt Morgan up later to ask him about it. Did you do some digging around on this Lee instruction from Lincoln County?
I just
Okay.
got the email today.
Cool. All right.
So no.
Okay.
Except he said it was agreed to, which I think
That was
may go to Andrea's point of why there needs to be training then. And to know where the training needs to happen, you need to get better statistics. So why this is probably something that is a training issue from a prosecutor's standpoint. Even maybe the judge would have still gone this way, but it definitely should have been argued.
Senator Hagan, your hand is up.
Yeah, I was just curious for an explanation on, in the bill itself, right at the, almost the top, 1A, the Class A felony. Just to
Sorry, which version are
explain
you
that.
looking at?
Why that, what? Oh, I'm looking at proposed amendment for today.
Okay. Yep.
Yeah.
Is it labeled A or B?
Is that still,
Are you talking
it's
about
A1.
Senator Hagan, 17A 208?
Yeah.
1A1 of current law
Yep.
that's not being effective? Okay.
Okay.
Yes. That's current law. Okay.
Please go ahead.
Just trying to understand, why is that differentiated? Why is it differentiated from the other B crimes? It looks very similar.
The violation of the Class A. It was a policy
Did I freeze?
decision that if someone does cause serious permanent disfigurement or loss or substantial impairment of the function of any bodily member or organ, that it should be. It was just obviously some legislator at some point said, you know what, that really is heightened because of the ongoing seriousness of what the victim trauma, the physical trauma, it sounds like.
Any other questions for Shira Burns? Not seeing any. Thank you. Does anyone need to ask questions of anyone else? We do have Carrie Capallo here, and I know you mentioned you wanted to talk to Mr. Morgan. Can you come back up and join us again?
So agreed upon instruction, was there a conviction or was there not a conviction?
I meant to look that up. It's a case that Walt handled. There was a conviction. I do not know if it was on that count or other counts.
Okay.
I can provide that in follow-up email. There likely is a newspaper article. Okay. I would say that I just took that instruction randomly because I spoke with Walt and I didn't have the opportunity to ask other members. And the commission that Shira and Andrea were members on did not have a defense member. So I haven't seen the other instructions that we're talking about. So we haven't really had the opportunity to kind of ban out to our members and see what other instructions might look like.
Thank you. Any other questions?
Yeah.
So we've taken a lot of information. Maybe we should take a break for a few minutes and mull it over. Janet, I thought that one of the things you said was very helpful. Maybe it'll be helpful for others also. The idea that there has been ambiguity and different interpretations of what has happened in the past in the statute and in the case law. So really the job of the committee now is to decide what it should be going forward. And that's a helpful, I think, as we go into some deliberations, a helpful way to think about it. So committee members, do you want to take a break for a few minutes? We'll go caucus and return. About 5 or 10 minutes? Great. We're just waiting for a moment because we need a senator. Okay. Welcome back, committee members, to our work session on LD 1572. I'll recognize Representative Sato for the purpose of making a motion.
Thank you, Madam Chair. And I think I'll just start by the original bill we had before us is very different in the discussions that we were having at the original bill, very different from the discussions that we are finding ourselves in today. And I think we have found a much more intense issue in the current statute for Class B aggravated assault regards to suffocation and strangulation that I think will require much more deliberation among the advocates, and I think will require its own public hearing, in its own work session, in its own right to resolve this policy issue. And so I want to thank everyone for coming together to try to resolve these issues in this very short period of time recently. And I hope that you have an opportunity going forward with more time to work on these issues more. and hopefully bring back a bill in the 133rd for this committee to ponder over once again. And so for that reason, I'll move ought not to pass.
Thank you. Is there a second? Representative Sinclair. All right, is there any further discussion, committee members? Yep, Representative Henderson.
Thank you, Madam Chair. I'll just make, a few remarks, and thank you, Representative Sato. I don't think that we're any farther ahead, at least I'm not any farther ahead than where I was last week. I'm maybe understanding the issue a little bit better, but nowhere closer to figuring out exactly the language that would make sense in this. And my 2 cents is I think 208 in general needs to be completely restructured and rewritten. And I have concerns with adding more ambiguous language into a state statute that's already incredibly ambiguous and that prosecution defense can't agree on. And I know I've said this off mic, but I'll say it on mic, and that is the best policy that usually comes towards the committee is one where the advocates, the defense counsel, and the prosecution can all agree on. They might not love it perfectly, but have come together on some kind of consensus on things that they could live with. And maybe selfishly, it makes our job a little bit easier, but also it lets us know that it's a really well thought through and well-rounded approach, and therefore is a well-rounded pursuit of justice. So I'll be supporting the ought not to pass today, but with real hopes that the advocates bring something back that is maybe a restructuring of 208 and a way for us to move forward in a thoughtful manner.
Thank you. Any further discussion? Okay, not seeing any. I think we're ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan. I have to hear you.
Senator Hagan, I think you're muted.
He's moving, he's moving. Senator Hagan.
Senator Hagan, are you able to turn off your mute?
I need to.
can't hear
I need to hear.
the audio is not on.
Oh,
Oh, we're muted again, aren't we?
no, it looks like it's going. Maybe turn up your volume?
There's no audio.
Oh, there we go.
I can't hear.
Oh, can you hear us now?
I have no, I can't hear.
It was a.
There's no audio. I'll call my vote in later.
Okay, thank you.
Representative Poirier. Representative Sinclair.
Yes.
Representative.
Yes, I'll
Sinclair.
vote yes. Yes. I don't know if you can hear me.
Okay, so Senator Hagan, this is an ought not to pass motion and you're voting yes. Is that correct? Okay.
Yes, we texted them, but we did.
I heard him. and
Okay,
see
I heard him
So
and I
those
see
are
him.
My
Okay.
rules. If that's okay, I will
Great.
mark him as being here. Representative Pugh. Representative Henderson.
Yes.
Representative Henderson votes yes. Representative O'Halloran.
Very reluctantly, yes.
Representative O'Halloran votes yes. Senator Talbot Ross. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin. Representative Caruso.
Very reluctantly, very frustratingly, yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Representative Poirier. Representative Poirier is absent. Representative Pugh. Representative Pugh is absent. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Babin. Representative Babin is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 9 members voting in the affirmative, 0 in the negative. 5 members are absent, and that is the vote of the committee.
All right, so that's unanimous of those present. Thank you, everybody. Thank you for being with us here today. We'll close that work session. I believe we have a language review, or we are ready to go.
See you later, Gata. One second. Thank you.
So this is the final language of LD 1965. This was a bill that you voted unanimously in favor of last session. It was held by the governor and didn't become law. And so for that reason was recalled so that you could fix the dates on when a report was due, because the report date had already happened before it would have become law. So if you'll look, everything on the first page matches what you had last year. You keep the emergency preamble, all of the amendments you had to who's going to be on the task force to create a court navigation program plan. All the directions you have for that plan in section 2 are the same as last year. The only thing changed is in section 3, the report would now be due next January 15th rather than last December.
Thank you.
And the fiscal analysis matches last time too.
Committee members, does that look good to you? Yep. All right. And you don't have anything else for us today? All right. All right. We'll take a motion to adjourn. Thank you. Second, all in favor? Perfect. We're adjourned. Thank you.